Good morning, Committee Secretary. Can we just confirm a quorum, please?
Good morning, Chair. We correct, Chair, and shall I do the roll call? Chair, shall I proceed with the roll call, Chair? Can you hear me?
Committee Secretary.
Chair, can't you hear me, Chair? Chair, can you hear me?
Ms. Sheldon, can you just check whether Mr. Hermans is on the platform?
Chair, he is on the platform. Are you able to hear us?
Chair, I'm on the platform, Chair. I'm not sure if you can hear us or...
Andre, I think you need to just call the chair quickly.
Okay.
Okay, no, that's fine. Sorry, my sound was muted.
Okay.
Sorry,
no,
Chair. I don't know if you called me. My reception's a bit bad, but I am here. Sorry, I don't know if you were calling me.
Chair, shall we proceed, Chair? We correct, Chair?
Just proceed with the roll call, yes. Thank you so much.
Mr. Mubayani?
Chairperson, good morning. Good morning, colleagues. I'm present. Thank you very much.
Good morning.
Dr. Ntwane? She's on the platform, Chair. Mr. Bergman?
Good morning, Chair, and good morning, everyone. I'm present.
Ning.
Mr. Mulder?
Good morning, Chair. Good morning, all. I'm present.
Ms. Mwatse?
Good morning, Chair, and good morning, colleagues. I'm present.
Good morning.
Mr. McPherson is present, Chair. Ms. Khonyana?
Good morning, Chair. Good morning, everybody. I'm present.
Good morning.
Mr. Malamatia?
Good morning, Chair. Good morning, everybody. I'm present. Thank you.
Good morning.
Chair, those are the members currently on the platform. The others will join us, and I'll keep you posted on that, Chair. Thanks.
Thank you very much. Can we flag the agenda, please? Thank you very much. Welcome to members of the Portfolio Committee and any other members of Parliament, to our stakeholders who are present to make presentations, and to Parliament staff. Can we have a move and a seconder for the adoption of the agenda, please, members?
Recording in progress.
Honorable Malamacha.
Thank you, Chair. I stand to move for the adoption of the agenda.
Thank you very much. Honorable Mbiani.
Chairperson, thank you very much. I support the proposal for the adoption of the agenda as reflected. Thank you.
Thank you. Then can we, with our agenda duly adopted, can we just check with the committee secretary on any apologies?
Chair, as indicated, I have not received any formal apologies. I'm assuming other members may still join us, Chair, and if they don't, I will communicate that to you, Chair. Thanks.
Thank you very much. But I do know that Honorable Monakedi has tabled an apology to Parliament. We'll just verify that.
I'll follow that up, Chair. Thanks.
Thank you. So to everyone on the platform, the Companies Amendment Bill and the Companies Second Amendment Bill was introduced in September 2023 in Parliament and referred to the Portfolio Committee of Trade, Industry and Competition for its consideration and report. In order to facilitate public participation in the legislative process as required by law, the committee placed adverts in print and social media calling for public comment on both bills. The committee received 41 substantive submissions as well as smaller submissions from the public in this regard. Today is the last day of public hearings and for the committee to receive oral submissions from stakeholders identified by the committee. As public hearings are held on the virtual platform, it becomes important that stakeholders comply with the request communicated by the committee secretary. Number one, all parliamentary rules in relation to hearings will apply. Number two, the chat room is for members' use, for staff of Parliament and departmental officials only. Failure to comply may result in removal from the platform. 3, each stakeholder will have 15 minutes to make their presentation, followed by a 20-minute engagement. 4, all stakeholders are reminded to switch on their videos when they present if they are able to. When you have completed your submission, you are free to leave the platform. If necessary, you are also very welcome to stay for the duration of the meeting, the public hearings here today. Our first presentation will be from Old Mutual, and it's Ms. Cleliwe Ross and Serena Meintjes who will do the presentation to the committee. You may proceed, Ms. Ross.
Good morning, Madam Chair. I'm just going to share my screen. My apologies, Madam Chair. We are a Microsoft Teams company, so Zoom is also an adjustment for me. Madam Chair, thank you.
Continues.
It does. Thank you, Madam Chair. Thank you for your indulgence. Madam Chair, good morning, and good morning to all the honourable members. And thank you for this opportunity to present our commentary and oral submissions on the proposed amendments. My name is Cleliwe Ross. I'm the Group Human Capital Director of the company. I also am responsible for group strategy and public affairs for our company. And I'm joined today by Serena Meintjes, who's our Chief Compliance Officer, and her colleague, Annemie Slabbert. The Old Mutual Group consists of entities that are licensed financial services providers and insurers that provide a broad spectrum of financial services products and solutions to individuals, small and medium enterprises, corporates and institutions across key markets in almost 13 countries in Africa. We also have a presence in other emerging markets. We now employ more than 30,000 people across the African continent. Overall, we are supportive of the proposals that are included in the company's amendment bill and what it is trying to achieve. We are, however, gravely concerned with the proposed incorporations of Section 30A, as we believe that it will introduce practical difficulties and have unintended consequences. The focus of our submission this morning, Madam Chair, is to highlight the material concerns that we have and also what we've included in our full written submission, which is not necessarily all covered in this presentation, Madam Chair. As a start, Old Mutual prides itself on its strong commitment to all our stakeholders, and we've prioritized an approach that we call to responsible remuneration. Over the last while, we've made some meaningful achievements in this regard. In 2021, we established a set of fair and responsible pay principles that have become the basis on which we support remuneration practices and decisions across our organization. Our principles aim to contribute to well-governed, effective remuneration systems that promote fair, responsible, and performance-aligned remuneration for all our employees. In 2022, we became the first insurer in South Africa to voluntarily disclose our pay ratios. That is the top 5% and bottom 5% of all our earners on a total guaranteed pay perspective, as well as a total remuneration pay perspective, which includes bonuses and variable pay. We intend to continue to publish these ratios in our annual reporting suite to support our responsible business culture. We have further demonstrated our commitment to responsible pay through intentional action plans. For example, effective the 1st of April this year, we strengthened our investment in our lower level employees and improved our competitive pay position We established a minimum total annual guaranteed pay of 180,000 Rand for all of our South Africa-based employees, and made a commitment to never pay below this level. In addition, we implemented a policy change to ensure that all employees that are appointed at Old Mutual are appointed at least at the minimum of our pay lines. This includes a commitment to adjust all incumbent employees in South Africa who were at below the minimum pay line at that time to at least the minimum of their respective pay lines. As a result of this commitment, Madam Chair, 87% of the employees that were impacted by this change were AIC employees, and 55% who benefited were women. However, Madam Chair, as I commented, we do have some issues and concerns and potential recommendations that we want to put forward this morning. The first of our concerns, Madam Chair, relates to Section 30A, subsection 9B, which states that the implementation report is not, if the implementation report is not approved, the non-executive directors who serve on the Remuneration Committee will be prohibited from serving on a Remuneration Committee for a period of 3 years after such non-approval. Madam Chair, our concerns are the following. The first is that specialist remuneration skills at board level are already scarce, particularly for listed companies and listed financial services companies. And because of the consequences of this proposal, we're concerned that this could cause a reputational damage for Remuneration Committee members. It could also act as a strong deterrent for directors to take the role of a Remuneration Committee member, particularly for listed companies, which will lead to a further remuneration resource challenge for us who need Remuneration Committee members, particularly in the South African market, and this critical loss of skills at board level would be detrimental. Furthermore, Madam Chair, our organizations run the risk of not having sufficient board members that have the necessary skills and capabilities to sit on a Remuneration Committee, especially when a step down of the full committee is required in the cases of non-approval. It will impact the board's ability to run and structure itself in a way that balances the necessary knowledge, skills, experience, diversity, as well as the interdependence of all of the subcommittees to deliver on the organization's strategic imperatives, which will make it very difficult for a board to perform its functions. Madam Chair, additionally, the immediate resignation in the event of non-approval will negatively impact the ability to effectively transfer institutional knowledge and will introduce the additional risk of overcommitment of our existing board members, who then need to subsume to the Remuneration Committee responsibilities before new board members can be appointed. Madam Chair, the proposed introduction of Section 30A, subsection 9, will give shareholders an opportunity where they could remand the organization in instances where their demands are not met by voting against the implementation report, knowing that such an instance the committee members will no longer be allowed to serve on the Remuneration Committee itself. The Companies Act already provides for effective measures whereby shareholders can remove a director by an ordinary resolution, and we are of the opinion that the introduction of additional measures as envisaged in this section does not add to the overall quality of governance in any organization. Lastly, Madam Chair, in this section, the implementation report is compiled based on a remuneration policy that has already been approved by the shareholders and which has to go through a formal process to be amended, if so required. And so remuneration decisions taken by committee members in respect of directors and prescribed officers in line with already approved remuneration policy decisions that already gives effect to the principles set out in the policy should not attract the proposed punitive consequence for non-executive directors serving on a remuneration committee, as it is disproportionate, it is not justified, and it is not commensurate, Madam Chair. Madam Chair, we do highlight 2 recommendations in our submission in this regard, and in as far as it applies to Section 30A, subsection 9B. Our recommendations are that we continue to align with international best practice, that shareholders are provided with an opportunity to issue a non-binding vote on the implementation report, in which case there must be a compulsory engagement with shareholders to resolve any concerns they may have. Secondly, Madam Chair, that members of the Remuneration Committee should not be required to step down after a single failed vote, and only be required to step down in the event of repeated consecutive failures to carry a non-binding vote. Madam Chair, we also have comments on the implementation report and the approval thereof. Madam Chair, this relates to section 30A, subsection 6, which requires the implementation report to be approved by shareholders. Our concerns with this approval or this proposal, my apologies, stem from the following: that the implementation report itself is compiled based on a remuneration policy that has already been approved by shareholders. Any amendments thereto must already go through a formal process in cooperation with said shareholders. We are concerned, Madam Chair, that the current wording is too broad and does not provide clarity on exactly what should be approved. For example, it is the expectation that shareholders should approve the quantum of remuneration, or should an approval be interpreted as an approval that the remuneration policy was appropriately implemented? This is not clear to us, Madam Chair. Secondly, unlike directors, shareholders do not have a specific right to be consulted on every business issue affecting the company, and neither do they have the fiduciary responsibilities or duty of care and skill towards a company. Shareholders elect the directors of a company who must act in good faith for proper cause and in the interests of the company, and they should not exceed their powers, maintaining unfettered discretion, avoiding conflict of their own interests and those of the company. They should act with care, skill, and diligence, and consider the legitimate interests and expectation of all stakeholders, making business decisions to enable the effective day-to-day operations of the company and ensure the successful implementation of the strategy and policies of the company. We are concerned, however, that this proposal amends the proposed amendments, my apologies, introduced in section 30A, will interfere with and irrevocably change the relationship between shareholders and directors, as shareholders will now hold the ultimate authority to reject the implementation report and remuneration policy as defined in section 30A subsection 1, irrespective of a decision that was in the best interest of the company. Madam Chair, it is uncertain how a non-approval would practically impact an organization's ability to effectively respond to non-approval and its impact on the remuneration of prescribed officers and directors of that company. The validity of actions and decisions taken by the company in respect of the preceding year is unclear and not covered in these proposed amendments. For example, Madam Chair, what is the impact of a non-approval vote on remuneration adjustments that have already been implemented in the reporting period, in accordance with the remuneration policy? Fourthly, the proposed approach to have the implementation report approved by shareholders is not aligned to internationally recognized best practice and principles like King IV, nor has this approach been implemented internationally in other well-governed jurisdictions like ourselves. We also do make recommendations in this regard, Madam Chair, and our proposed recommendations are as follows: that the shareholder vote on the implementation report should be non-binding, and non-approval must trigger a compulsory engagement process with shareholders. Madam Chair, where shareholders are not satisfied with the implementation of the remuneration policy and or the discretionary actions that are taken by the board with regards to executive remuneration, the remuneration policy itself should be amended and approved to address those concerns and to clarify the extent of discretion that the board has in terms of the policy, as opposed to being bound by fixed rules and formulas that are provided for in the policy. And lastly, Madam Chair, to provide specifically a subsection that the failure of the ordinary resolution on the implementation report will not invalidate the actions which are then reported on, provided that these actions were taken in accordance with the approved remuneration policy. Lastly, Madam Chair, in our submission, we did make some requests for clarity, which I will now highlight. The first request for clarity that we have, Madam Chair, is for section 30A, subsection 1. We would appreciate more detail as to the minimum information that is to be included in the REM policy itself, in the remuneration policy itself. Our second request, Madam Chair, pertains to section 30A, subsection 2. We request clarity on what constitutes a material change that would trigger a need to present the remuneration policy to vote on again. Thirdly, Madam Chair, we request clarity on section 30A, subsections 5 and 6. These appear to contradict each other, Madam Chair, as subsection 5 states that voting on the remuneration report constitutes voting on the remuneration policy and the implementation report, whilst subsection 6 clearly stipulates that the implementation report and the remuneration policy are separate documents with separate voting requirements. Madam Chair, clarity and consistency would be appreciated as to which of these elements of the remuneration policy and the remuneration report require specific resolutions to be passed. Lastly, Madam Chair, we'd appreciate clarity on section 30A, subsection 9B. Here, Madam Chair, we require clarity on the timing of the required step down of the remuneration committee members as a consequence of a failed implementation report vote. Madam Chair, that is the end of our submission. We're happy to take any questions.
Thank you very much, Ms. Ross, for your presentation. Can I now hand over to committee members for interaction with this presentation? I'll take hands from committee members. Honorable Malamacha.
Thank you, Chair. Let me take this opportunity and welcome the presentation. Also, be very much touched the manner in which they understand our objectives and what we want to do and what we want to achieve and their support. It's just I want to emphasize one thing, Honorable Chair, that any dismissal, firing, or requesting of stepping down of a member as a result of a resolution, that will be as a result of collective had to sit down and agree to arrive on that particular resolution and implement it. It is a fair democratic principle that says the collective has sat, decided not to discriminate, has gone through all the facts that they think the person concerned was given enough fair chance, and it has proven beyond reasonable doubt that this person deserves this. Therefore, resolution can also be used even in court in a form of evidence that it's not a one-man show who decide. We have decided as collective. Therefore, I want the old mutual to bear in mind that we are in line with democracy and democratical principle in ensuring that we don't do things out of the book. I just wanted to emphasize that here. Thank you so much.
Thank you very much. Any other members which wish to participate? It seems as if your presentation was very clear, so you may respond to the member who asked, who interacted with your report. Ms. Ross, thank you.
Thank you very much, Madam Chair, and thank you to the honourable member who raised the comments, it sounded like to me, which is fair. I do want to highlight, though, that, Madam Chair, in the principles of corporate governance, the roles and responsibilities of shareholders and non-executive directors are very clear. Very clearly set out in the Companies Act, but also against all of the other governances that we hold ourselves true to, including King IV. And giving shareholders disproportionate rights to make decisions, especially over non-executive directors who are appointed by the company and voted for by shareholders, it starts to create an improper power balance in that regard. Particularly because while shareholders can vote for the appointment of non-executive directors, and rightly so, they can also use the REM vote to vote against other company decisions that are within non-executive directors' rights to implement. Chair, we did raise in our submission that we're highly supportive of many of the changes and really are supportive of disclosing pay differentials and pay parity in all of our organizations. It is the responsible thing to do in corporate South Africa and across our continent at large. Our challenges relate to only that subsection, and that relates to the roles and responsibilities that REMCOM members have to perform. And Madam Chair, we get concerned by the resultant decision, what it will result in, Madam Chair, because then many REMCOM members will actually not see it as worthwhile to serve on a REMCOM. The punishments are highly punitive for REMCOM members, and it is already a great challenge for us, particularly in South Africa, to find remuneration committee members with sufficient experience, with sufficient skills and capabilities, particularly for listed financial services providers, Madam Chair.
Thank you very much, Ms. Ross. I think that concludes the interaction and the presentation from Old Mutual. Our next presenter is from Allan Gray, and it is Nicole Hammond and Rain Adams. Over to you, Ms. Adams and Ms. Hammond.
Thank you, Madam Chair. Let me just share my screen. Please let me know when you can see it.
Yes, we can see it. If you can just go into presentation mode.
Sure. There we go. Good morning, Madam Chair and honourable members. My name is Nicole Hammond. I'll be presenting on behalf of Allan Gray, and I also have my colleague Rain Adams on the line. Firstly, we want to say thank you to the Portfolio Committee for this opportunity to present on such an important bill. A brief overview to start. Allan Gray is a privately owned investment management firm established in 1973. We invest in JSE-listed companies on behalf of our clients with a focus on generating long-term wealth for them. Our clients are the shareholders in the companies we invest in, and we act on their behalf when we engage with companies and provide voting recommendations. As long-term shareholders, our clients benefit from good corporate governance structures. At the core of our governance efforts is encouraging robust executive remuneration structures and strong boards of directors at companies. The shareholder rights afforded to us in the Companies Act and the JSE listings requirements are really the greatest tool we have at our disposal to reinforce good governance. During our 50-year history, we have often leveraged off the Companies Act when we want to escalate our shareholder action. As a result, we are invested in preserving and enhancing the existing shareholder rights of our clients, and that is why we welcome the opportunity to present today. Our clients include individuals, retirement funds, insurers, medical schemes, and companies. While we act in our clients' interest as shareholders, in many ways they also represent other stakeholders. The thousands of retail investors in our unit trusts are also customers or employees. The retirement funds that we invest on behalf of are in some cases the employees' retirement plans at these companies. And when we focus on executive remuneration, that often includes non-financial components such as safety at mines or patient care at healthcare providers. That is really the lens at which we view shareholder rights. It is that good governance is really to the benefit of all stakeholders. For our verbal submission, we would like to just focus on the two pertinent points to us from a shareholder perspective, and that is the proposed changes to the remuneration policy and the implementation report consequences for directors should the report fail. Our feedback is really focused on how we feel the proposed amendments would affect the current process as it applies to JSE-listed companies. Firstly, on the remuneration policy, to briefly recap the current process under the listing requirements, policies are tabled annually as an advisory resolution, and where companies obtain more than 25% shareholder opposition, they are required to invite dissenting shareholders to engage. Albeit an advisory resolution, we do feel that this has the effect of requiring 75% shareholder support. And importantly, it provides a platform for minority shareholders to engage with companies because that invitation to engage is there. And in this case, minority shareholders are shareholders who in aggregate have more than 25% voting rights and have recommended dissentingly on the resolution. Because the resolution is tabled annually, we do find that engagement with companies is frequent and remuneration policies improve on a continuous basis. Under the proposed amendments, it would see policies tabled as an ordinary resolution, only requiring 50% shareholder support, and once approved, it would only be required to be tabled every 3 years, provided no material changes are made. Under the proposed process, we feel this effectively lowers the shareholder approval required from 75% to 50%. Importantly, there's not a clear platform for minority shareholders to engage with companies. The frequency of the vote also changes from annual to every 3 years. A few of the previous presenters have mentioned that this aligns with international best practice. We would humbly disagree with this point. In our view, just based on the UK that does have a 3-year binding vote through our exposure with the dual listeds, is that these companies only reach out to shareholders every 3 years and they only make changes on their remuneration policies every 3 years. So what you have is shareholders are effectively locked into a certain policy for 3 years, and there are a lot of annual elements to executive remuneration. The current process in the listing requirements was introduced by King IV and implemented by the JSE in 2017. So we do have 5 years of data to reflect on to see how the proposed process might affect the current process. This graph looks at the remuneration policy support the JSE Top 100 has obtained for years ending 2018 through to 2022. As you can see, 83% of these resolutions obtain more than 75% shareholder support. 16% obtain between 50 and 75% shareholder support, and only 1% of these resolutions actually obtain less than 50%. This represents the current process, so the effective 75% shareholder approval, and 17% of these resolutions that failed to obtain 75% shareholder approval would have been compelled to invite dissenting shareholders to engage. This would be the current or the proposed process, apologies. So where we feel we are effectively lowering the approval required for shareholders, and more importantly, there's shareholder engagement that previously took place between this 50% and 75% shareholder support level that we would be losing because the requirements are unclear. And as I mentioned, only 1% of these resolutions actually get below 50% approval. But importantly for us, that in our view, that is not a reflection of the JSE having particularly high quality remuneration policies in place. It is rather, in many cases, just a function of the ownership makeup and that it is difficult for these policies to get more than 50% opposition. We do feel the current process can be improved in terms of communication between companies and those representing shareholders, but it is largely effective in capturing minority shareholder concerns. There also seems to be a perception that by moving from an advisory vote to a binding vote, we are strengthening the shareholder rights, and that might be true when nothing else is changing in the process. But in this case, there are a lot of elements that are changing. We are moving from the effective 75% to 50%. The frequency is changing from annual to every 3 years, and the shareholder engagement invitation is no longer there, which we are most concerned about. So it is really in combination of all these changes that we feel the proposal in its current form will not strengthen the existing shareholder rights for JSE listed companies. Our recommendation is that Section 30 should differentiate its requirements for listed companies. And for listed companies, we recommend the process outlined in the listings requirements be incorporated into the Act. Importantly, however this policy proposal progresses, we think it's very important that there be some mechanism to capture engagement for minority shareholders, and that that engagement invitation does not only take place below the 50% level. The second amendment we wish to outline is the consequences for remuneration committee directors after a failed vote. The current process in the listings requirements is the same as that for a remuneration policy, and there are no direct consequences for directors. As other presenters have mentioned, shareholders do approve directors on appointment, and 1/3 of non-executives stand for re-election annually. Under the proposed process, we wish to use this time to just highlight the concerns we have on the direct consequences, whereby REMCO members are ineligible to serve the REMCO for a period of 3 years following one failed vote. It's important to note implementation resolutions do fail slightly more frequently than policy resolutions. And for the most part, what we have seen is high shareholder opposition. It does act as a catalyst for change. So REMCOs use it almost as ammunition against management to go ahead and make significant improvements. As many others have stated, we feel REMCO members have a very specialized skill set. It's unlikely these directors will continue to serve the board if they are deemed ineligible to do so for 3 years. Many listed companies make use of remuneration consultants. These consultants advise REMCO, and they are often used for a period of a few years. As was mentioned in the King Committee presentation on Monday, a very good point is that remuneration consultants are paid by the very management on whose remuneration they are meant to advise. So we think it's very important that REMCO members have the experience and expertise necessary. Otherwise, they will struggle to push back against both management and remuneration consultants when it comes to the details of the scheme. The 1-year time frame, also referred to as the 1-year strike rule, we feel is too punitive to reasonably expect changes to be made. In our experience, cases of positive shareholder activism, it does take time. It takes time for REMCO members to build trust with management, and it also takes time for a constructive relationship to be built with shareholders. And that is why we feel a 1-strike rule is not in place anywhere else in the world, because that time frame, it's just too compact for changes to actually be made. Overall, we feel it would be damaging to the value proposition for South African directors. Capable individuals will not want to serve on remuneration committees, affecting both the quality of SA boards and the quality of remuneration schemes. We do feel there is room to improve the accountability of directors in the current process. We find there is sometimes a timing mismatch. In the year that we have significant remuneration concerns, the REMCO chair is perhaps not up for re-election in that year. But we do think the proposal can be more balanced. Our recommendation is that the chairperson of the REMCO, as well as the chairperson of the board, stand down, and that is after following 2 successive failed implementation report votes. The chairperson of the REMCO, because they are ultimately responsible for the committee decisions, and it's often only the chair that is engaging with dissenting shareholders, not the entire remuneration committee. And the chairperson of the board, because remuneration is approved by the board at the recommendation of the REMCO. And then we feel 2 successive failed votes is a more realistic time frame. We do provide companies with our voting rationale when we do recommend our clients vote negatively on their remuneration, but we do recommend a more formal requirement is in place because this is a concern a lot of companies have raised with us. Then if implemented in its current form, we do recommend a minimum tenure requirement for REMCOs before being scoped into the consequences, such as a tenure of 12 months. To briefly touch on the proposed wage gap metric, as it has been covered in detail, if we are solely talking about curbing excessive executive remuneration, a possible solution could be mandatory disclosure on the history of pay versus performance. And the US has something similar in that's required, where they require the history of the CEO pay for 5 years versus certain metrics like total shareholder return of the company and total shareholder return of a peer group. Disclosure of this nature makes it very clear when companies are overpaying executives relative to performance. If we are talking about broader pay inequality, then we would agree with the other presenters that we feel there are better suited metrics available, such as the Employment Equity Act forms that categorize the entire workforce and take into account factors like gender and race. In conclusion, we are very supportive of the objectives of the amendment bill, being to increase transparency and increase accountability of directors. It is just that we feel the amendments we've highlighted can be incorporated in a more balanced manner. And while I spent a lot of time speaking about the remuneration policy, I would like to stress our main concern is really the implementation report consequences for remuneration committee members. Thank you, Madam Chair. That is all for our presentation.
Thank you very much, Ms. Hammond. PC members, your opportunity to interact with the report, with the presentation. Can you remove your presentation from the screen, please, Ms. Hammond?
Yes.
Honorable Malamacha.
Thank you, Chair. Allow me to take this opportunity to welcome with warm hands the support given by Alan Gray We really appreciate, and their concerns, I think we heard them, but we really appreciate their support, an equivalent one. Thank you so much.
Thank you very much. Honorable Mbuyane.
Chairperson, thank you for the opportunity. Let me also welcome and appreciate the presentation, Chair. This company is 50 years now. And I just have two clarity-seeking questions. The implementation resolution fail more frequently than policy resolution. I need clarity on that one. And also, there's a room to improvement in terms of our accountability of directors in the current process. And also, he indicated of timing in terms of mismatch between shareholders and directors. Can I have more clarity or from the presenter? And also, she made mention that they support the objective of the Company Amendment Bill in terms of the transparency and also the accountability. And that is key for this committee, hence that is why you are here today. Thank you very much, Chair.
Very much, Honorable Mbuyane. Ms. Hammond, your response.
Thank you, Honourable Chair and members, for the questions. Maybe I'll start with the one on if it was the mismatch between the timing. So often we have, because the resolutions are tabled annually, we'll have serious concerns on how a remuneration report has been implemented. And during that year, we might want to recommend our clients vote against the remuneration resolutions, policy and implementation. And then we might also feel it's so severe that we want to recommend against the chairperson of the remuneration committee. But because only 1/3 of non-executive directors stand for re-election annually, that remuneration committee chair might not be up for re-election. So then we are unable to recommend against them as kind of a signal of that we are extremely unhappy with the outcomes. And then for implementation reports that fail more frequently, what we do find is a lot of the time with remuneration, the devil is in the detail. So it will be on implementation that we can really see how a remuneration policy in its holistically has been executed. And most of the implementation reports that do fail, we actually see that it relates to when a CEO leaves and then companies have, high exit packages. And that's not something that can really be outlined in the policy. It will be very broadly outlined. These are the leaver provisions for a CEO, if they are a good leaver or a bad leaver. But then on implementation, it's really up to the board discretion. So a lot of the time when we see high shareholder opposition on implementation reports, it's because shareholders often disagree with the way an outgoing CEO has been treated. Perhaps they performed very poorly, but the company is then viewing them as a good leaver and then giving them a significant payout. So in our view, there's really a lot of daylight between a policy and how it's implemented. A policy is very high level. A policy can look very strong and look like it has the right financial metrics that they're paying executives according to. But then when you see on implementation, there's a lot of adjustments. There's a lot of add backs. There's a lot of subtleties that then skew the outcome, and they are not actually being aligned with performance and what we think is in the best interest of shareholders. Thank you, Madam Chair. I think that was the two questions.
Yes, thank you very much. You did well on the responses. I think you really clarified the committee. Thank you very much, Ms. Hammond, for being part of our meeting.
Thank you, Madam Chair.
Yes, thank you. We now move on to Computershare, and we have Benny van der Westhuizen, who will do the presentation to the committee. Over to you, Mr. van der Westhuizen.
Morning, Madam Chair. It's Teresa Finnie-Cax. I'll actually be doing the presentation. Benny's our CEO, but he will also then. Thank you, Madam Chair. All right, let me just start. Can I share my screen? Okay. Okay. First of all, we'd like to thank you for the opportunity to present our oral submission of our comments to the Portfolio Committee. We intend to focus on two issues. Firstly, the issue around access to the securities register information. And the second is around shareholder communications and some of the challenges that relate thereto. We've included the sections of all the different sections in the Act that cover the requirements. However, because of time, I don't intend to go through each section in detail, but I will reference the various sections and we can come back to it if required. So I think, first of all, in order to, I think it's important to give some background to give context to our comments. So first of all, Computershare is a CSD participant in the Straight environment. So they look after the dematerialized securities on the dematerialized or uncertificated securities register. And then Computershare is also a transfer secretary, or also referred to as an issuer agent. We currently service 216 listed companies on the JSE, and we have approximately 1.2 million shareholders in our records. If you look, it's important to understand how the securities register of a public listed company works and how it operates in practice. So in this diagram that I've got here on the left, you have your issuer that's at the top. The issuer has an obligation under Section 50 of the Companies Act to maintain a securities register. In many cases, especially with public listed companies where there are very large numbers of shareholders, the issuer will outsource that function to a transfer secretary, and it's all the administrative functions. So everything relating to the facilitation of meetings, all investor communication, the maintenance of the actual securities register, and all the processing. We facilitate all corporate events, whether it's the schemes of arrangement or the like, and also the payment of dividends, and we also handle all unclaimed dividends, etc. So those are typically the functions that are performed by an issuer agent on behalf of an issuer. You then get where shares, if their shares are held in paper form, so there's still a share certificate to evidence title, that securities register is looked after by the transfer secretary on behalf of the issuer. If the shares have been dematerialized, in other words, they are converted to electronic form, they are then held under Straight as the Central Securities Depository. Under Straight, there are 8 approved CSD participants, of which Computershare is one. And each CSD participant has what's known as a sub-register. The sub-register of each CSD participant could comprise of the CSDP, I'll refer to as CSDP, CSDP's own nominee. It could also be a broker's nominee, because brokers in the Straight environment are required to appoint a CSD participant, or it could be the shares directly in the beneficial owner's name, in the name of an own named client. So if I'm the shareholder, Teresa Finikak, my shares sit directly in the sub-register as opposed to being held under a nominee. So these underlying registers are sub-registers. What happens in practice, currently on a weekly basis, each CSDP is required to provide a beneficial owner download, which is referred to as a BND, to Straight with details of their underlying shareholders. And the JSE on behalf of brokers does the same thing for brokers' underlying clients. Straight then collates those securities, the uncertificated securities that are held in those sub-registers, and provides an uncertificated securities register back to the issuer agent or the transfer secretary. The issuer agent then combines that together with the certificated shares, if there are any, in order to give the issuer a view of its entire register. So the reason I've gone through this detail is I think it's important to understand what is involved in putting together a register, whether it's for public inspection purposes, and then also in servicing those underlying clients. When we're talking about shareholder communications, which we'll go into a bit later, or in servicing those clients, that register is spread across several regulated intermediaries. It is not all in one place. Okay. All right, so that was the first thing I wanted to touch on. The first issue that we wanted to highlight to the committee is around access to the securities register. While we fully support and understand the requirement for transparency, there are just a few things or things that we would like to highlight to the committee. First of all, dealing with Section 26. So there's various sections in the Companies Act. Section 26(1) provides a beneficial interest holder or shareholder a right to inspect a register without any charge for the inspection, and then to get a copy upon payment of no more than the prescribed maximum charge. And then similarly, there is a clause under Section 52(2) of the Companies Act, which provides for inspection of the uncertificated securities register. And it states there that that register should be provided within 5 business days, and it should be as close, based on the information, as close to the business, the day of the request. With regard to Section 26(2), deals with the right of a third party or the public to get access to the securities register. Currently, there is a fee, a maximum fee of 100 Rand for inspection, but there's no fee currently prescribed for a copy. I know that the intention of in the Companies Amendment Bill is to make both the inspection and copy subject to a prescribed maximum charge. Also, just to note that that right currently is an unqualified right. So without going into the detail of what each section states, I think our key issues that we want to highlight is the cost to the issuer or to an issuer agent like ourselves to actually make that information available, to provide it for public inspection. So that month, the beneficial owner download currently is provided on a monthly basis to the issuer. Whereas if the issuer needs to request an ad hoc beneficial owner download from Strate first has to get those 8 sub-registers from each CSD participant, collated. They also charge their own fee. So you're looking at a minimum charge of about 24 to 27,000 Rand to be able to create that register to be available for public inspection. Also, if you're looking at the costs, so it's fine if a shareholder asks for their own records is one thing, and that's easy to do. If shareholders request full register, there may be a number of schemes of arrangement. So there may be historical systems involved. So we might need to go back and look at archived records, etc. Also, there are other complexities. I mentioned there are large volumes of shareholders. If you look at a company like a Sanlam, for example, there's over 300,000, I think even 350,000 shareholders. So to create that register, it involves administration, it involves overheads, our systems, etc. So there's a number of factors that just need to be considered in considering the costs, the maximum cost that is charged. One of the things that we could look at, if Strate was provided that beneficial owner download to the issuer on a more frequent basis, also to meet the 5-day turnaround time in Section 52, that might be an option, but then at what cost and who bears the cost, for providing that register? Another alternative may possibly be to look at aligning the fees with PIA or what's provided for in the company's PIA or POPI manual, because that normally will include costs relating to resource costs, timelines, production, and from a process perspective. The second item that we want to highlight under access to the securities register is looking at the intention of the requester. So at the moment, I said that right is unqualified, and as I mentioned initially, we fully understand and we support the need for transparency and access to information. We are aware, though, that there are some tracing agents that they obtain the register, they then identify accounts with what I'll refer to as your lost shareholders who haven't updated the information, and they then cherry pick. And so we've got instances portfolio values of 6 million or 3 million, large portfolios, and they then cherry pick and trace those clients, and then they charge up to 25% of the portfolio value of the shares, to that shareholder in order to, for tracing and for then handling, or for assisting them to claim the dividends or the shares that actually belong to them. We believe that this is not in the best interest of the shareholder. It is a matter we have raised with the FSCA, and we are aware of the intention to look at possibly regulating tracing agents. However, when it comes from a company's amendment perspective, we are proposing that the issuer should have the right to refuse access if it's not for a bona fide purpose. Also, just wanted to highlight that in the UK companies legislation, there is a requirement to provide the reason for access, when you have receive a request for public inspection. Okay, I then want to move on to the second item that we wanted to highlight today, and especially looking at the practical challenges around shareholder communication. So a issuer will have, they have certain objectives and things, and there's 4 main concerns I want to highlight. First of all, a public listed issuer needs to comply with ESG initiatives. They are trying to reduce their carbon footprint and, reduce the amount of paper and printing, etc. And at the same time, obviously, to look at, saving costs, communicating, so meeting all the legislative requirements, but doing that in the most cost-effective manner. Secondly, as you, I'm sure, are aware, there are 876 post offices which have been closed. 1,333 post offices are open, so almost half of the post offices are currently closed. That does cause problems, and you'll see a bit later, I've actually got a slide that demonstrates the implications, of the post office closure. Thirdly of all, what happens in practice is you have very tight deadlines for corporate actions that are imposed in terms of the JSE listing requirements. So for corporate events, in order to send election forms to shareholders so they can participate in a corporate event, or to send them a notice of a meeting, that often what is happening now, if we only have a postal address for them, we're bound to send post. They're lucky if they get it 3 months after the event, if at all. So the modern trend is to use SMSs, or to use and issuers publish information on their websites, and that increases efficiencies, allows the shareholder to receive the information in real time, so they can get the best benefits and actually participate in those meetings and corporate events. The fourth thing we want to highlight is that we are aware that there's a fraud syndicate that intercepts post, especially the returned mail, and then uses that to commit fraud. Without going to, I don't have time to go into the detail, but I mean, last year we had a attempted fraud involving a portfolio of over 12 million rand, where someone purported to be an attorney handing an estate, and we know, we're aware that they got that information by intercepting an item in at the post office. And that's just one of several attempted frauds. So there's also a fraud risk that needs to be considered. All right, I just want to mention challenges. One of the challenges around shareholder communications is that currently I explained how the register fits together. So each CSD participant and broker is an accountable institution from a anti-money laundering perspective in terms of the FICA legislation. They have a duty or obligation to verify their clients, and they keep that information in their records. But that information is not readily available to the issuer. So the issuer can't then use that to ensure that they communicate, and reduce, to increase the emails, addresses, etc. on record, and cannot use that to assist with shareholder communication. There are also concerns around conflicts with POPIA and confidentiality. So those brokers and CSDPs have personal information of their clients, and obviously have to comply with POPI and confidentiality requirements. So are reluctant to provide that information to the issuer to include in the securities register and for communication purposes. The other point is that the 1973 Companies Act included a definition of a sub-register. Remember I explained the sub-register is your nominee and then any own name clients, but your sub-registers is then what sits under the nominee. In the new, and I say the 2008 Companies Act, that definition of a sub-register was removed. It only refers to an uncertificated securities register. So regardless of where the shareholder sits, okay, they are on the uncertificated share register. An unintended consequence is that an issuer, when they're sending communication, has to send communications to all shareholders, not just to at the sub-register level. When we're looking at practical implications, so each CSD participant and broker already has an obligation to communicate with their clients, and they have their own platforms and mechanisms to communicate with their clients. So this is effectively resulting in duplication in the issuer having to send a meeting notice or a corporate action notice, etc., to the underlying clients. It's already also being provided by the participant or the broker. Okay, on this slide, I just want to mention under Section 62, there is a requirement. So Section 31 deals with the right of a shareholder to receive a publication of any financial statements. Section 62 refers to a AGM notice, including at least a summarized form of the financial statements to be presented, and then also directions to obtain a complete annual financial statements for the preceding financial year. There are sections in the Companies Act, Section 610 and 611, which provide for electronic communication. So that is fine. They allow communication via electronic communication. The problem, though, comes in under Regulation 6, Regulation 7.1, and then Table CR3 limits that electronic communication to email only. It doesn't recognize all forms of electronic communication. And then it also only recognizes registered post, not even ordinary post. So that then has, that is the concern that we're trying to raise. I just wanted to demonstrate two practical examples. So on the top here, if you look, so these are the records that are held by CSDPs. This is the number of shareholders that are held by the various CSDPs, and this is the number of emails that are on record. The balance then has to be posted. If, however, if the issuer only had to post to the CSDP nominee or the CSDP itself, and they then on distribute, it would save a whole lot of costs, relating to the preparation, the printing, of those communications to go to underlying shareholders. The second example below, and this is one of our, it's actually one of our largest issuer. So there are 363,202 shareholders on record. Of those, we only have 185,668 email addresses on record, and the balance has to be posted. If, however, we were able to use SMSs as a means of communication, we do have, of those postal items, there are 120,296 cell phone numbers on record. So if the Act allowed for communication via SMS, that would also resolve a large, reduce the amount that has to be communicated through the post, and would resolve a number of the issues that relate to that. Okay, so I'm going to pause here, because this is the practical implications of the requirements as they stand now. So many of our issuers, so there are some issuers that, will maybe, and depends on the legal interpretation, will use a more, I can say, relaxed interpretation of the company's legislation. But a lot of the issuers are afraid to, that if they don't comply and send by post, that, that there could potentially be a meeting that's overturned, or, if there's a dispute, a shareholder says that they didn't receive an item, that, that could invalidate a meeting. But this is now, and this post here is a daily basis, on a daily basis. You can see it's even broken the table. We have a bakkie that goes to the post office on a daily basis, and you can see the bags of returned mail, items that are not delivered. Remember that half the post offices are closed in any event. So this is the consequence. And remember also that these are the items that are being intercepted by fraud syndicates, etc., and are then being used to commit fraud. So this is the practical implications, of complying with the legislation in the Companies Act as it stands currently. If I can say, in the modern world, okay, we've got an Investor Central portal, and I know other financial institutions, have various investor or client portals where information can be obtained electronically. It's secure. Information is received instantaneously, so it improves efficiencies, etc. And it can even be viewed on a cell phone. And most individuals do have cell phone devices, these days. So it's a much more effective means of communication. So I think just in closing, so our proposal is first and foremost that the Companies Act and the regulation should recognize all forms of electronic communication, not only email and not only registered mail. It should also include normal post. And like I said, in practice, there are much more efficient means of electronic communication to ensure the shareholder receives the information that is, so they can make elections, participate in corporate events, participate in meetings, etc. And then also that the obligation should be on the issuer to only communicate to the sub-register level, to the nominee at the nominee level or own name clients, not to all underlying clients. And then lastly, that Section 62 of the Companies Act that deals with the requirement to include at least a summarized form of the financial statements. What happens in practice is issuers will often put the AGM notice, the financials on their website, and they send a notice of availability, and the AGM notice can refer to that link on the website where the shareholders are able to download or access the summarized financials. Thank you. That brings me to the end of my presentation. Are there any questions?
Thank you very much, Ms. de Klerk. Committee members, I see the hand of Honourable McPherson.
Thanks, Chair. I just want to touch on the communication point. I think it's a well-made issue, which probably only just increased costs for businesses. So if there was communication that was diverted to an SMS platform, how would that then affect your still ability, because people change their numbers all the time. That's just the nature of people with phones. But I'm sure that that's not dissimilar to people changing addresses. So how do you contemplate that people have multiple numbers and change their numbers regularly? And also, do you not think that there should be a responsibility on shareholders to inform companies when, in fact, their details do change? Because it seems like the onus and cost is on the companies to try and track people down and to find people and to communicate with them, but there seems to be no responsibility on shareholders to inform them on change of circumstances or details. Your comments on those two. Thank you.
Thank you. So firstly,
thank you very much. Can you just hold on a minute? Allow me to chair. Members, any other hands? Okay, there's no other interactions. Ms. de Klerk, you may respond.
Thank you, Madam Chair. So with regard to the shareholder communications, as an accountable institution, remember I mentioned to you that brokers and CSDPs are all accountable institutions. We have an obligation to keep our records up to date. So as you transact with the shareholders, and there are means of tracing information, to validate or to verify, to keep those records up to date. But you're absolutely right. There is an obligation on shareholders to also keep their information up to date. In fact, we recently obtained a external legal opinion, and they basically, one of the things they said that, if this were to go to a court would look at what would the reasonable, man do. So as much as the issuer is trying to get communication to the shareholder, you're right. The shareholder has an obligation to also ensure that their information stays up to date. Unfortunately, it doesn't always happen. I don't know. My colleague Lindiwe Mvalasi, so she's head of legal. I don't know if she wants to add anything. She's had the engagement with the attorneys. I don't know if there's anything additional she would like to raise here.
Okay, Ms. Mvalasi.
Thank you, Madam Chair. Thanks, Teresa. Just to add on what Teresa has already alluded to, so the requirement on shareholders is muted in the Companies Act. So it is almost an implied duty that a shareholder has from the MOI of the company when they first subscribe to the shares of that specific company. Therefore, there is a duty on a shareholder to keep the company updated. But what we also do as an issuer agent is that we constantly double check the cell phone numbers with our third-party service providers to ensure that we have up-to-date information. And with addresses, it's sometimes a bit difficult because you don't have an ID number or you don't have even an original address with the older registers. But with newer numbers and newer registers, it is much easier to keep up to date with those provisions. Thank you, Chair.
Thank you very much. And thank you for your presentation to the committee this morning. Do you have a follow-up question?
Yeah, Chair, just a follow-up question if I can. Would it, if the issue is moot on shareholders having to update information should it change, would it be a useful amendment to the bill or to the act to require shareholders to inform either a third party or the company directly of a change of either email, cell phone, or address, which could then possibly streamline communication between companies and shareholders, and also reduce costs? Would that be a useful amendment to the Act? Thanks.
Thanks. Ms. Mvalasi, are you going to take that, or Ms. Niekerk?
I can take that, Chair. Thank you, Mr. McPherson. That would definitely be absolutely helpful. Because it would move the obligation to an issuer who has no control and has a large number of shareholders to keep track of, rather and move that obligation to the individual to make sure that their details are current and up to date.
Thank you. Ms. Niekerk, do you want to make any concluding remarks, or even Mr. van der Westhuizen if he is on the platform?
I have nothing further to add. Thank you, Madam Chair.
And Mr. van der Westhuizen is not on the platform. Okay, so that concludes Computershare. Thank you very much for presenting to the committee and for interacting, allowing the committee to interact with your presentation.
Thank you so much.
Thank you. Our next presentation is from Abantu for Global Equity, and it's Nkomo.
Chairperson, if I may, Chair. We just have a challenge of getting hold of Abantu, Chair. ACBIS is available to present, so they have indicated so they can, the next on the program we can proceed, Chair. Not to be posted, just to check your WhatsApp messages, Chair. Thanks.
Oh, sorry. Okay, my apologies for not checking. So it's now ACBIS, and it is Mr. Grosby. Ms. Grosby.
Ms. Grosby.
Yes, thank you very much. You may proceed with your presentation. And thank you for your flexibility.
Good morning, Chairperson, members. Can you hear me?
Very clearly, thank you. Proceed.
Thank you very much. Thank you for the opportunity. My CEO, Mr. Theo Boshoff, is also online, so if needs be, he will assist with answering some of the questions. I'm going to switch off my camera and share my screen, Chairperson.
Thank you.
There we go. Thank you very much. Chairperson, so just very quickly, our organization, who is AGBIS, we are an association of agribusinesses operating in South and Southern Africa. Our key constituents are the banks, some of the big banks, development finance institutions, insurance companies involved in agriculture, commodity organizations, and many other input suppliers and associations involved in the agricultural value chain. Our function is to ensure that agribusiness plays a constructive role in the country's economic growth, development, and transformation. And we want all agribusinesses of all sizes to be able to thrive, expand, and be competitive. Our inputs on this bill are informed also by the need to improve the ease of doing business and to remove any barriers to entry. There are our members, Chair. You can have a look if you're interested to see what our membership looks like. Some general remarks from our side. We subscribe to the principles of good governance and corporate governance as set out in the King IV report. We're also members of BUSA, so we support the BUSA inputs. I know that they have already made a submission to you. And in addition to that, many of our members are listed on the GSE and they also adhere to the principles that are prescribed, the listing requirements by the JSE. So, Chair, while we understand the need for measures to guard against corruption, we are want to point out that some of the proposed interventions in the bill may increase the regulatory burden on companies. In our view, interventions should be commensurate with the size and the means of an entity and capable of acting as a safeguard against corruption. We also want to caution against unintended consequences of some of the provisions. And I've been listening to the submissions, Chair. I know the word unintended consequences have come up on a number of occasions already. One example is that we are concerned about that the amendments are likely to make it more difficult to recruit top staff if they know that their remuneration and personal details will become public knowledge. This may inadvertently add to the leadership crisis which we are facing as a country. This bill, as well as the Second Amendment bill, make various improvements to the Act, which we welcome and support, and our submission will only focus on the few points where we do have some concerns. The first one is Clause 4, which will be amending Section 26. And the new Section 26 will give the right to any person to inspect and copy annual financial statements of public companies as well as private or non-profit companies with a public interest score that is under the threshold that is prescribed by the Minister. This is also an area, Chair, where we are concerned about possible unintended consequences as a result of the broadening of access to annual financial statements in particular. The amendments remove the qualifier in the current legislation that the person must have a beneficial interest in the company in order to access these documents. We believe that there should be a requirement to prove sufficient interest by such a party before access to all the documentation should be permitted. We are particularly concerned about the risk of anti-competitive behavior, as unrestricted open access to any person may facilitate corporate espionage or even allow competitors to gain vital company information. The cost of compliance should also be factored into this requirement, as private companies and non-profits in particular need to minimize their overheads in order to remain competitive. In many cases, the Promotion of Access to Information Act already sets out the rules for access to information that is held by public and private bodies. Clause 5, amending Section 30, This section seeks to match the benefits received by directors or prescribed officers in the annual financial statements with their identities. We submit, Chairperson, that there are other ways in which accountability can be achieved without necessarily violating the privacy of the individuals in question. If stakeholders are aggrieved with the remuneration policy, they can vote against the policy as it already outlines the benefits based on position. Likewise, if there are suspicions of ill-gotten gains when the company, sorry, I just lost that. Sorry, Chair. There was something that popped up on my screen and I lost my place there. So the no, I was at section 5. So if there's talk about ill-gotten gains, then the company or regulatory authorities could access the relevant information to conduct a lifestyle audit. So there are other alternatives to deal with this kind of concern. Exposing the benefits of each individual might also lead to victimization and cause attention within the working environment. In the normal scope of work, the remuneration of employees is confidential information, which the HR department has a responsibility to safeguard. Then clause 6, which deals with the insertion of a new section 30A. This clause deals with the duty to prepare and present a company's remuneration policy and remuneration report in the manner of compiling the report by the public company. So ordinarily, remuneration is a responsibility of the board of directors, and in most instances, the remuneration committee only makes recommendations to the board. But this amendment now requires the policy to be approved by stakeholders at the annual general meeting. So we fully accept, Chair, that stakeholders do have an interest in the remuneration policy and can make positive contributions towards ensuring equity within a public company through their input. And the King IV codes already seek to promote stakeholder activism by calling for stakeholders to vote on a non-binding advisory note that the board must take note of. We believe that this provides a suitable mechanism as it promotes accountability without divesting the directors of the authority that they require to direct the affairs of the company. Shareholders do not owe a fiduciary duty to a company like directors do, and therefore they cannot be held accountable if wrong decisions are made that prove at the end of the day not to be in the interest of the company. So the requirement for the remuneration committee members to stand down for re-election in the case of the non-approval of the implementation report could also result in unintended consequences, such as directors not wanting to serve on the remuneration committee because of the perceived reputational risk that will be associated with that. So with regards to the proposed clause 33F, which deals with the median and the ratios between the highest 5% and the lowest 5% of earners, we want to point out that the pay gap disclosures may not necessarily be an accurate reflection of the fairness and equity of a company's remuneration policy. And we do believe that agribusinesses may be a bit of a special case because they are vertically integrated in the agricultural value chain. Many agribusinesses operate companies that combine elements of primary production, so your farming, with value-adding activities such as packaging, processing, distribution of those products, and other services such as marketing and finance. So the implication of this is that a large agribusiness may have employees ranging from unskilled and semi-skilled involved in the primary production to highly qualified professionals required to administer these large enterprises. Also, Chair, agribusinesses often operate in rural municipalities where service delivery is a problem, and there are also few schooling and job opportunities for the spouses of employees. And as such, these agribusinesses often pay a premium to attract employees to these rural towns, and it's sometimes difficult for them to retain, especially the professional people in the rural spaces. furthermore, because of the decline in the service delivery in many of the rural towns, many of these businesses have taken it upon themselves to perform certain of the basic service delivery functions that are normally performed by municipalities. And in order to do that, they then employ unskilled workers, which they often appoint at minimum wage level to do the service delivery that should be done by the municipalities. So these pay ratios, Chair, we believe, reduce equity assessment to mere numbers. And we would like to argue that it may be more accurate that it cannot be accurate to use the mere percentages and median pay to compare vertically integrated agribusiness with some other companies which might be constituted in a very different way and may not have these complexities that we have in the rural areas. We believe that consideration should also be given to other factors by which companies contribute to society, such as the development programs that they may have, internships, bursaries, graduate programs, skills transfer, and many other contributions. Then clause 7, dealing with section 33, which is about the information in the annual financial statements of private companies, which will in some cases now become public information. We also have a concern about that. We believe that the information is already accessible to interested parties such as beneficial shareholders, certain judgment creditors, and trade unions. Other interested parties can make use of the procedure set out in PAIA in order to obtain relevant information. So there are legitimate concerns that this provision may impact on the right to privacy and may also lead to anti-competitive behavior. Then clause 12, dealing with section 72, in terms of this amendment, all public companies, as we understand it, will in future have to have a social and ethics committee, not just listed public companies. And the bill also seems to require that all members of the social and ethics committee must be non-executive directors. We believe that this is a bit restrictive, and it would probably be better to have both executive and non-executive directors as members of the social and ethics committees, with the majority of them being non-executive directors. Thank you very much, Chair. That is my submission.
Thank you very much. Members of the Portfolio Committee, you may interact with the presentation from Agbiz. I'll take your hands. Honorable Mbiani.
Thank you very much, Chairperson. Just two clarity-seeking questions from Agbiz. The one are the unintended consequences as a result of broadening access. That means if we broaden access of information, then we'll be causing some consequences that are unintended. And also the disclosure may not be an accurate reflection of the fairness and equity of a company remunerations policy. What can be said there in terms of the clarity? Because I don't clearly understand what the statement means. Thank you.
Okay, thank you. Thank you very much, Honorable Mbiani. Agbiz, Ms. Crosby.
Thank you very much, Chair. So as far as the access to information is concerned, what we are arguing is that there are sufficient mechanisms for interested parties to get access to the information. But some of that information is confidential, may be used in a manner that is anti-competitive, and for that reason, we believe that anybody wanting to get access should be able to substantiate why they need access. If they cannot do so under the current provisions or under PAIA, it shouldn't just be open for everybody. So that is what we're arguing there, Chair. as far as the disclosure of the pay information is concerned, I think what we are trying to say to you is we think it is a lot more complex than just looking at the top 5% and the bottom 5%. If you really want to look at equity and evaluating a company, you need to look at it holistically. And we think that just looking at these top 5 and bottom 5% might create a skewed perception of what is actually going on in a company. And also companies differ a lot amongst one another. And we're saying that in our space, which is the agricultural space, the companies have a particular profile for certain reasons, and it might be difficult to compare them with companies that operate in the big centers. But Chair, I don't know if my CEO might want to come in as well.
CEO, Mr. Boshoff, yes, I see your hand. You may proceed.
Thank you very much, Honourable Chairperson. Perhaps just quickly to elaborate on one or two of the issues. Looking at, for instance, base remuneration pay, you have systems such as Pyromenes, of course, that has 21 different grades of jobs, job gradings, and of course the median, the average, the outlier pay for each one of those. I think the point my colleague was making is it's very rare that you have companies that would have level 21, the base level, and level 102, for instance, highly educated skills in the same company, in the top 5 and the bottom 5%. So their agriculture, and especially agribusiness, might be a bit of an outlier. If you compare that to, for instance, a consultancy company where you might have, we might range from, say, level 6 to level 3 at max. The differences between the top 5 and the tops and the bottom 5 would obviously appear to be much greater. But our point was just that it must be read within context of how would employees, based on their job grading, for instance, how does that compare to the industry standard? But if one simply compares one company to another company without taking the diversity within the companies into consideration, it might not give you the full picture. So I think, and then just finally, my colleague did also allude to it, but the unrestricted access to company documents without having to prove an interest. Our sector in particular, but other sectors obviously are extremely competitive, and you do see consolidations and takeovers and companies trying to buy out other companies. And there is a real risk that if there's no real requirements and no qualifiers in terms of who can gain full access to your financial information, a potential competitor that might want to, especially, I'll take an example, if you're in negotiations for a merger or a takeover, to get unrestricted access to all of the finances without having to necessarily prove an interest in it, might put one company in a distinct disadvantage in those negotiations. So that's why we do that. We understand, obviously, stakeholder activism is very important, transparency is important, but there are certain instances, and that's why I propose perhaps some qualifiers where maybe it might be placing a company in a distinct disadvantage if they have to disclose all of their financial information. Thank you, Chair.
Thank you very much. I think that clarifies the member. Thank you very much to Agnes for this presentation. I think we can take one other presentation before we break for tea. Can I just check with the Secretariat who will be next?
Chair, the next stakeholder will be Consumer Goods Council for South Africa. They are willing to. No,
thank you very much, and it's Ms. Chieke. Thank you. You may proceed. I think you have a computer. That's another one that's on near you.
Good morning, Chair and members of the Portfolio Committee. Thank you for this opportunity granted to us. legal registered name is GS1 South Africa, and we're trading as the Consumer Goods Council of South Africa. I will put my presentation.
Can you just put your presentation in slide mode, please?
Is that fine now,
There
Chair?
we go. Yes, yes. Thank you very much. You may proceed.
Chair, my name is Neo Momodu. I'm the executive for the Legal Regulatory Stakeholder Engagement of the Consumer Goods Council. I'd like to apologize on behalf of our CEO, Ms. Zinhle Kikwe, who at the last minute could not join us because this presentation was moved forward, and at this time she has other commitments. Also joined by our legal counsel, Mr. Sizwe Tsai from SGA Law, who will be taking us through the formal presentation in relation specifically to the Companies Amendment Bill. But before we do that, Chair, if you may allow me, I'd like to give a brief background about who the Consumer Goods Council is. We're an industry association representing about 9,000 member organizations in the consumer goods, retail, and services sectors, otherwise known as the fast-moving consumer goods sector, and one of the largest employers in this in the sector. We employ about 2.5 million people. Well, our members collectively employ about 16% of the national workforce, and we contribute about 1 trillion of the 5 trillion annual GDP, which is about 20% of the GDP. And, you know, we play a very critical role of distributing billions of rands every month through our retail outlets of SASSA grants. And we are beginning more and more to provide services to government where government is not able to reach the most rural communities, because as you know, in any community, you will find a retailer or a manufacturer. And through our outlets, we're beginning to say, for example, a Clicks Group or a Dis-Chem, to say, how can we provide medical services that, you know, are very close to communities so that they don't have to travel far? And we're engaging to make ourselves relevant so that we're able to service our government effectively. And if you look on the left side of the screen, you will see that we play the critical role of transforming an economic contribution to the country, either through capital investment, and that's why it's critical for us as the Consumer Goods Council that we create an enabling environment that can actually attract investment into the much-needed investment, given that almost a crisis situation that not only South Africa is going through, but around the world with economies struggling. We provide consumer value. You know, our motto as the Consumer Goods Council is we enable our members to trade better so that they're able to provide consumer value. And one of the key examples is that we take our role of providing food on a daily basis seriously. You know, our members work tirelessly to ensure that when customers go to our retail stores, food is available. And that's why, you know, in this day, in these the last few weeks where, you know, we have shortages of either eggs or poultry, we're continuously worried, and we're actually saying that let's work together as communities to actually make sure that we provide food to our consumers. From a jobs creation and skills development, you know, this is one of the sectors that I told you that how we contribute about 16% of the workforce. And it's the kind of environment where you have people that we can employ people that are straight from university all the way up to executive level. And that's why, bills such as the Companies Amendment Bill are very critical for us. And we welcome most of the provisions that have been proposed in the bill, and later on, as I mentioned, we will mention some of the things that we find, need to be looked at by the portfolio committee. SMME development is a very key part of the work that we do. Not only do we service big retailers, but through, many of our divisions, particularly the Global Standards Division, which is a GS1 standard, where every product that comes into the market, we are able to verify and give it a barcode so that, we have standards that these products subscribe to, and that are recognized not only locally but globally. That's why when we have outbreaks, and the one that I can mention was listeriosis a few years ago, we were able to pinpoint where that problem existed, and we were able to take products off the market very, very quickly. And I'd like to appeal and just to say that in this day and age where we are seeing more and more of illicit products coming into the market, and unfortunately, we have seen, deaths, whether they are related directly to foods, and I know there's investigations currently happening that we're saying that it's important that we actually start as a country to subscribe to standards that are able to, identify products as authentic, and consumers are constantly, educated so that they're able to make informed choices about products that are authentic, and also for the law enforcement agencies, by using the GS1 global standards, are able to identify those products that should not be in the market. And this is the work that we're continually doing, and we would like to appeal to all stakeholders to actually become vigilant and actually support these standards so that we actually provide authentic products, not just foods, but it's products across the board. And then from a food security, safety and security point of view, this is something that we take security very seriously, and I've just spoken to it, but what we want to highlight is that some of, we will be engaging with the portfolio committee, this one and others, to say that we need to look at creating a regulatory environment that enables food to be donated in this country. Currently, if you look at the Consumer Protection Act, as an example, Section 61 thereof prohibits or makes it very difficult for food to be donated in this country. And this is a travesty, given that we have millions of people still going to bed hungry, and then we should be creating that regulatory environment. And lastly, and it's not least, to say that, localization, more and more of our members are starting to say, how do we make sure that we create an environment in South Africa that we produce proudly South African products and we support the local economy? And this is something that we continuously do. These are some of the examples of the work that the Consumer Goods Council does. And this is our mission, to be the leading platform of engagement for the consumer goods and manufacturing industry. And our mission is that, we represent all of these members, and our key is to say we are there to engage on non-competitive matters that actually push the industry, drive economic recovery, and also make sure that our consumers are served effectively every day. These are some of our board members, all of our board members. We have about 27 board members. It is a very big board, and these are brands that you are familiar with, that you engage with on a daily basis. And I just thought, Chair, we should give you that kind of sneak peek into the work of the Consumer Goods Council, so that you understand who we are, so that when we go to the next slide, that I will hand over now to our Legal Counsel, Mr. Sizwe Cai, to actually take us through the presentation. Thank you, Chair, and over to you, Sizwe.
Thank you very much, Neo, and greetings, Chairperson. Greetings to the members of the committee and everyone present. Neo provided a brief overview of the structure of our presentation. I would like to start by saying the CGCSA is a member of BUSA, and so we are aligned to the submissions made by BUSA and the other business organizations such as AgriSA, which has just stepped off, which are also members of BUSA. So broadly, on the principles that they've outlined in their submissions to the committee, we are by and large aligned. So what we'll try to do in our presentation is not to repeat what they have already dealt with. I think committee members have been here since Tuesday, if I'm not mistaken, so we'd like to just elevate the issues that we want to emphasize from our viewpoint. And I think before I go to the detail of the presentation, is also to just start by acknowledging the work that was done by the drafters of the bill, as well as all the policymakers involved. By and large, there is an acknowledgement that the comments that we have been coming through from industry, from the practitioners who are involved with the Companies Act, have been taken into account to make some of the improvements. And one of the things that we want to do is to, for example, highlight the issues that we consider to be positive amendments which are coming through from the bill. starting by acknowledging the proposed amendments in terms of the Section 38A of validating shares issued irregularly. This is something that was there under the old Act. The courts always had those powers, and we are happy to see that that has been brought back. Again, in terms of proposed Section 40, the issue of the transfer of partly paid shares, in the context of the implementation of empowerment transactions, we do see that that proposed amendment is going to have a positive impact in the industry insofar as being able to implement empowerment transactions much more quicker and getting the shares in the hands of the intended beneficiaries. And lastly, also to highlight the simplification of the processes around the share buybacks. So insofar as those issues are concerned, we are very happy with the proposed amendments. Also, around the issue of the reduction of the cooling off period for the auditors from 5 years to 2 years, we were very happy with that amendment, and we'd like to acknowledge the good work done in that regard. In my next slide, if you can change, we also just want to acknowledge the positive improvement insofar as the amendment of Section 45 with regard to the provision of financial assistance to subsidiaries. This is something that we do welcome. However, our reading is that there's room for further improvement in this section, and we've highlighted that in our detailed submission, which is to say that if you look at the nature of companies that Neo shared earlier on in the presentation, to say that most of the member companies, it would be group companies. As a result, what you will have is a requirement to be able to move money around or whatever resources amongst the group companies. It may not always be the holding company that has the resources to provide assistance. So what we'd like to see as a further improvement with regard to the proposed amendment to Section 45 is to actually make it possible to provide financial assistance amongst companies of the same group without having to resort to comply with the complicated process of getting all the approvals. It would make transactions flow much more quicker if financial assistance is able to be provided to companies in the same group. We can move to the next slide. Yeah, so I think perhaps most of the people who've appeared before the committee from a business point of view have had concerns around the proposed amendment, the insertion of the proposed 30A. And there are different approaches, and perhaps our viewpoint is that the angle we're coming from is slightly different, but we agree with the principle. So the starting point is to acknowledge that at the moment, shareholders have a lot of powers that they are given in terms of the Act. One, starting with the ability of shareholders to appoint directors into companies. And secondly, shareholders have the power to approve the remuneration of non-executive directors to the board. Equally, they have the powers to remove directors should the need arise to remove any director. Now, what is being inserted in Section 30A as proposed is that now shareholders must have powers to approve a policy. Let's forget that it's a remuneration policy, but at the practical level, it is a remuneration policy which is an operational policy of the company, which ordinarily rests in the exclusive powers of the board. Because the architecture of the Companies Act is very clear that it is the directors who have the powers to take charge and run the affairs of the company. Now, to be able to run a company, it means that you must enjoy full powers to approve all the policies that you require in order to exercise your powers as a board. What is being proposed here is that the powers to approve something as critical as the remuneration policy of executive directors. So executive directors are employees. They are employed by the board and they account to the board. Right. and then the board is accountable to shareholders. Now, once you say that a policy must be approved by shareholders, the implication of that is if you need to make changes to that policy, you will require the approval of shareholders. And that is going to have unintended consequences, and it is going to make it very difficult for boards to assume full responsibility for the affairs of the company. And one of the concerns that is coming through here is that what we are seeing is that public companies are going to be affected disproportionately now, because one of the things that is not obvious in the market is that there are many large private companies which are competing with the public companies, which are not subjected to the same onerous regulations which keep on flowing through to public companies. Our view is that the current framework in terms of the King Code for public companies and listed companies is very much adequate insofar as allowing shareholders to participate and have their say in so far as how executive directors are remunerated. Because the threshold in terms of the King Code is that once a remuneration policy is not approved by or there's shareholders representing less than 75% do not vote in favor of the remuneration report, what you then have is the company is obliged to engage with the shareholders, because the key principle here is that the views of the shareholders must be taken into account. Now, once you make it an approval, even at a lower threshold, you just risk a situation whereby, for example, you may not understand why the shareholders voted in a particular way and what is it that you need to be doing. And as a result, you will be throwing boards and shareholders into very operational matters, and that is going to disadvantage a lot of companies if they have to be bogged down into such issues. So we take issue with the very first section 30A1, and every detail that flows from there. I think it would not be a useful exercise to say modify this, modify that, so that it can become workable. We are just going to create a lot of administrative burden if we permit this section to be inserted in a Companies Act. That is not to say the issues being raised are not valid issues that society needs to be concerned with, and that Parliament cannot regulate through other available avenues. And in our view in this regard, we can just go to the next slide to talk to this. So at the moment, we have under the auspices of the Department of Labor what is known as the Commission for Employment Equity. We believe that they are more competently placed, they are more competent to deal broadly with issues of remuneration, unequal pay, and so forth, because the interest here is not, for example, I mean, we go to issues of disclosures and so forth. The interest is not to just have information on pay disparities being made public and then it doesn't serve the purpose. What we'd like to see is the information on pay disparities being collected by a competent government body that will then be able to use that information to make informed policy proposals in terms of how we can take the country forward insofar as this issue is concerned. But more certainly, this is not something that now should be legislated in the Companies Act. That is our viewpoint. And then we want to move on to the last slide. I said we're going to be very brief because we've already been accommodated. Our viewpoints have been put across by BUSA and other business organizations. And from a CGCSA point of view, the main concern really, and it is something that we hope we can engage with this committee going forward, is to look at the current environment in South Africa to say, are we bringing up policies and changes that are going to enable business to trade more? And I think once we are bringing up amendments and legislation which will make it difficult to do business, then we're making South Africa less attractive as a place to do business. We are seeing a lot of resignations, for example, of executives from listed companies. And one of the concerns is the over-regulation. And they are very much aware of what is happening to their counterparts in the private companies, which are not subjected to the same level of regulation. As a result, it is becoming more attractive to work for a private non-listed company as opposed to working for a listed company that is subjected to over-regulation. So I think this is the spirit that we would like the committee to look at these regulations, to say every time you increase regulation for public companies, they are being made to be less competitive compared to their private counterparts. Thank you very much, Chairperson. I'd like to hand over to Neo to make concluding remarks.
Thank you very much for this opportunity to present to you. I just want for you to see on the screen, and I spoke about this illicit trading, that we are really now pushing for standards to be adopted, and we want to please appeal to every stakeholder to really support. And there's a hotline that members of the public and anybody who comes across these products can call. It's an 0800 number, 0800 014 856, and it's one that we would like to actually say even a kid from school should be taught this number, so that we are all work together towards actually eliminating these products that are very harmful to us. With that, we thank you for this opportunity to make this presentation. And Chair, over to you.
Thank you very much. You may remove your presentation. Portfolio Committee members, there we have the presentation. Committee Secretary, must just check. I'm unable to switch on my video. Can I take hands for interaction with the presentation, please? Honorable Malamacha.
Thank you, Chair. Opportunity to also appreciate their support. We warmly welcome that, and we think it's a good step towards the right direction, especially working with people of their magnitude. However, Chair, I want to make a strong emphasis that, and this must have a reference to their point where they are saying the proposed bill requires the remuneration policy and remuneration implementation report to be approved by an ordinary resolution of shareholders. An ordinary. I want to emphasize the issue of who we are. We are a democratic state. In a democratic state, much things are done transparently so. And when you are doing things transparently, the emphasis is of fair, free participation of every participant. Now, shareholders, they too need not to be limited in terms of having participation. And participation without having rights to decisions is as good as you are just a spectator. So I don't think directors must ever feel that they are taking some powers from them, but instead they must be very much happy that whatever they are doing is be more democratically, because it has got a buy-in of everybody. Now, if it is the director as opposed to what we're proposing and as in the manner in which they want it, it is not far from where you will have a lot of objections, a lot of queries, a lot of suspicious things. And I think the emphasis must be more to say we want to see things done transparently and accountably to the public, and it must be owned by every participant rather to be objected by the very same shareholder in the long run, that directors are doing as they wish. Chairperson, that is my contribution to that. Thanks.
Thank you, Honorable Malamacha. I'll allow you just, it was more of a comment, but just to round off and respond if you wish to.
Chair,
I don't know from you. Okay, there we go.
Thank you very much, Chair. Before I hand over to our legal counsel, I'd like to say that we are for the principle of democracy, of transparency, and of ensuring that every stakeholder has got an opportunity to have access to information that governs companies, particularly listed companies. However, we are saying that there are certain considerations that we need to actually take into consideration to ensure that there is not an extra burden that's given to companies, particularly if there are already instruments that govern companies elsewhere, like the example that Sizwe made in terms of the employment law. So, Chair, generally, like we said, we really do espouse and support some of the provisions that are given by the bills. However, the ones that we've highlighted, we think that need to be considered. But Sizwe, before anything, I'd like to hand over to you to address specifically the question that was raised by Honorable Mangamecha.
Yes, thank you very much. Yes, and just to echo what Neo is saying, we are 100% aligned on the issue of transparency. So the issue of what executives are getting paid, that information must be made public as it is currently the practice. So where the challenge comes in is when you reduce, because now an ordinary resolution requires approval by 50% of directors. What that means is it then becomes a binding, shareholder resolutions are binding on the company and the board by extension. The fear that we have at the moment is that if there's a policy that has been amended, that has been approved by the shareholders, it goes without saying that the board cannot, during the period between the AGM and the next AGM, implement any other policy that other than the one that was approved by the shareholders until the next policy instrument is approved by the shareholders. And we need to look at this thing in the context of the legislative framework of a company. You have the Act, you have an MOI of the company. The shareholders' rights are very much protected in the Act, they are very much protected in an MOI of the company. The board will never do anything to interfere with the MOI without the approval of the shareholders. Now, what we are dealing with is a more secondary instrument, which is a policy now. That has always been the terrain of the board, because the board must have flexibility to deal with the policy matters so that it can be able to attract the kind of talent that it needs to attract to the company, to make the company more competitive. Now, once you say you are restricted by remuneration bodies that was approved by the shareholders 17 months ago before the next AGM, and you can't bring in people the way you need to make the company competitive, it will have unintended consequences. So we need to, yes, this can be strengthened, and we are not opposed to strengthening the accountability mechanisms and transparency requirements, but don't reduce a policy to something that must be approved by shareholders. Then you are making them operational. Thank you very much.
Thank you very much. That concludes the presentation and interaction with the GCS1 presentation. Members, I want to beg your indulgence that we push through without a break. We only have 2 more presentations left. So unless you strongly disagree with me, I want to push through and now give an opportunity to our Bantu for Global Inquiry, Ms. Nkomo, who will do an oral presentation. Over to you, Ms. Nkomo.
Thank you so much, Chair, and thank you so much to the Portfolio Committee for the opportunity to present. I'm also wearing another hat, which is the National Strategic Plan on Gender-Based Violence, Pillar 5, which is on economic power. Amongst the key things we do through that multi-sectorial agreed program is to really look at what type of economic policy discourse from a policy perspective that is presented by Parliament. So we take time to come in and comment. We made a presentation, for example, last month on the public procurement bill to the Portfolio Committee of Finance. So so the economic cluster is an area onto which we make presentation. So my presentation, Chair, is really, my oral presentation is really going to be also focusing on the gender perspective associated with the presentation. But let me just say that Chair, firstly, I endorse the previous presentations, I think from GS Consumer Goods, if I got them right, on the socio-economic impact of the bill, because I think that's quite important. And why we think we support it, it's because every regulation anyway, particularly, has an impact in the economy. So in essence, we must be able to test that and see, because that impact could either be positive or negatively. So for instance, if there's an increase requirement for compliance and governance for listed companies, the implication is that it would mean that they would have to employ a lot more. And if there's less, so it means that there are certain things that they're going to be doing. So there's something that I want to raise it. So firstly, from a gender perspective, we think that the bill is really silent, and it doesn't seem to, and around the equity issues. So if you talk about the gender imbalance in the corporate leadership, right? So the bill lacks provision in terms of requiring companies to maintain a minimum representation of women on their boards. Now, I know that there could be similar argument that you already have other prescripts that guides that, but there's absolutely nothing wrong for this bill to be more explicit about, gender participation. That's the first issue. The second one is really about the economic empowerment issues, and that the bill does not comprehensively address the issue around the economic power of women, which is a crucial factor in achieving gender equality within the firm. So it's really still quiet. And obviously the key question for us from gender perspective is, what is it that the bill seeks to achieve, and what is it that it wants to correct? Now, already from companies who are listed on JSE, issues are a mandatory requirement. But also for unlisted companies, how do we make it sure that actually they do comply to some form of framework around gender balance in the leadership? So there's a key question around the listed and unlisted companies, and how to make sure, and what instruments that exist to manage the issues of gender transformation, but also how to strengthen those instruments. That's one. And then the second issue I want to raise, it's a loophole that on a social and ethics committee, that the bill allows large companies to evade establishment of social ethics, and if they employ more than 50 individuals. This provision could enable significantly companies to avoid scrutiny of their social and environmental impact, which is inconsistent with the bill. Now, this is a very important point, again, just to ensure that the company, from a perspective of transformation, but also ensuring that the issues of gender equality are actually embedded within the operations of the company. But also the other issue, it also means that, in fact, the unlisted companies in particularly, who are not subjected into a similar scrutiny as those who are listed in the JSE, would actually not, will never be able to understand their social governance and as well as the environmental impact. But also fundamentally that some of these companies would never are not likely to commit to any form of gender transformation program. The other component that we think it's a serious loophole is that the bill lacks a bit of a clarity and definition of what constitutes a social responsible investment. So it's quite consistent with the previous point around the social ethics. And I think that's something that we need to talk about. Now, what becomes very, very important is that post-COVID, there's been a very clear scrutiny of the role of business in contributing in social justice, but also in ensuring that it sees itself as part of a social discourse. So in essence, it will mean that we need to be able to really kind of like give a very broad framework on what is socially responsible, right? And because if we don't, then it leaves the room for companies to engage in greenwash activities that may inadvertently harm women and marginalized groups, and sometimes workers. But I think COSATU will probably deal with that matter much more later. And then the other one, Chair, it's around there's a possibility that the bill could actually allow a continued exclusion of women in leadership position, and I think I've made that point quite emphatically. The other one, it's around the gender pay gap issues. Now, the previous, speaker makes a presentation and say that the Equity Commission is better appropriately meant to deal with that. And I do think that when we celebrate 30 years of democratic dispensation and we're still confronted by exactly the same issues, we can't therefore use same issues of a gender pay gap. You can't then use the same instrument to make it sure that you achieve Section 9 of the Constitution, which is around ensuring that there's equity and inclusiveness within the economy. It means, therefore, you then need to take what we call a multidisciplinary approach in ensuring that you actually achieve issues around gender pay gap. So, in essence, we can't therefore rely on just one instrument. In fact, we've seen how companies using that one instrument could easily just pay penalties that are imposed by the Equity Commission, or just declare that we are not able to meet this area of work, and we will still continue to work on it. And hence, we're saying that from a gender perspective, we think that that's something that we need to look at. So, several recommendations from our side. Firstly, we're proposing that the loophole on social and ethics be closed. That's the first issue. The definition of socially responsible, we need to have that. We actually do support, by the way, the issue of shareholders being involved in the remuneration policy for a number of reasons. In economics, we have something called moral hazard, where in fact directors enjoy so much power to actually do as they please within how they run companies. But also we've seen cases globally where in fact companies are run outside of, and particularly the remunerative issue, where directors are paid extremely enormous salaries, which is actually not consistent with either the company unto which they work in, but also to the economic environment unto which the company operates. I mean, you would recall, Chair, the open discussion we've had about the recent CEO Sibanye, who was actually going to be taking home a bonus of about 370 million when in the mining sector has not only been shedding jobs, but the South African economy, in fact, has been experiencing an increased unemployment crisis, which is currently sitting at 32.9. So there is a mismatch there. Hence, in fact, I do think that the call for social impact of the study is important, but at the same time, we actually don't need to take conservative ideas around where we take the economy to. We also think that there needs to be the bill needs to talk about gender pay equity, some form of an enforcement, right? Because one of the key things that has actually been happening as a practice in private sector, and I mean, let me just say generally labor market, is that when in fact, an employee leaves the place who happens to be a man, moving somewhere else, is that what companies do is that when they're employing women for diversity and inclusion purposes, they would then revise the salaries. They would never pay the salaries exactly in the same, the same salaries that would have been paid to a previous incumbent. Now, there has been as well, the issue around the need for incentives for gender diversity. Now, there is a proposal, and I think the social impact study needs to come through. There is a proposal from some of our, partners who would say, companies who are actually meeting gender diversity should be given incentives. We don't think that we want to support that because, in essence, it will mean that the Section 9 of the Constitution, which really refers to ensuring that opportunities and economic opportunities specifically are created on the basis of equity and inclusion. It will therefore mean that we are not, that section of the Constitution is not kind of like presenting a very strong case. So we think that the tax incentive should not be something that we consider, and that we must be quite clear about what that the companies must actually comply with what the Constitution and the law currently stands. Let me pause there, Chair. Thank you so much for the opportunity to present.
Thank you very much, Ms. Nkomo, for that insightful presentation. Members, here we have Honourable McPherson.
Thank you, Chair. Thank you, Ms. Nkomo. I see that next to your name is economist, so I assume that you are an economist either by profession or by trade. And I would just like to ask if you have any research that supports the concept or idea that I think you essentially were advocating for, that the pay of CEOs or directors can't be at what it is in an economy that may be as sluggish as South Africa, and whether there is any study that links lower pay with a struggling economy, and that then should be rather linked to the overall status of the economy as opposed to the performance of the company. And secondly, whether there's any research that links the sort of pay grades or pay gaps between workers and CEOs and directors, and reducing inequality or poverty. Where there is any research or studies, I'd really like to read them. I haven't seen any myself, but I would just wonder if you have any access to those, or may be able to forward those on to us. Thank you so much, through you, Chair.
Thank you very much. Can you speak to it now, or will you share some documentation with the committee, Ms. Nkomo? Over to you.
Yes, thank you so much, Chair. I mean, I'm quite happy to just give an really high level reflection on the question, and I could share. So let me just talk about, for example, if you look at the Nordic countries whose economies are extremely stable, but also if you look at the salaries that get paid to executives, is actually quite concave, which is in this context, it's around ensuring that it contributes to egalitarianism. So let me then make several points. Is that South Africa, and just to say, yes, I am an economist, but I prefer to be called development economist. So the issue is that if you're confronted with a dualism in an economy, amongst the key things is that you need companies that demonstrate a much more social consciousness in how they undertake their business. That's the first issue. The second issue is that high wages, and this one, there is this work that has been undertaken by OECD countries that disparities in terms of in wages actually naturally perpetuate wage inequality in the economy. And when you have wage inequality and the net effect is going to be asset inequality, the next one is going to be wealth inequality in any society. So, and therefore, what you then need to start looking at is to really say, what type of compact that we could agree with as all the economic sectors or a society of what we seek to achieve. Now, what we seek to achieve in the Constitution, Section 9, is quite clear. But also actually in practice, then you have, it's a contrast of what the society, what our Constitution seeks to achieve. And as such, and even if I digress for a second and just follow my thought process about how you see some of this contrast, both in terms of what's happening in the private sector, but also even in the public sector as well. So you see most of the resource allocation going towards, fiscal policy and supporting social security. 59.2% of the GDP gets to support social wage, and then less than 10% of the GDP is spent on supporting what we call industrial development. But the point I'm trying to raise, the intersectionality that I'm trying to bring to your attention, member, is the fact that if there is actually no alignment and a clear compass of where you want to take society to, and how do you build a resilient economy, then you see this misnomer around, a massive wage inequality, allocation of resources on in certain sectors, lack of productive capacity or lack of resources that gets channeled to productive capacity of the economy. So just to close, the point is, there is sufficient research that shows that when there's consensus amongst, critical actors of the economy, which is business, government, and society and workers, where in fact there could be an agreement around the nature of wages that gets paid, but also how you then address wage inequality in the economy. But I'm quite happy, Chair, as well to share some of these studies for the benefit of the member. Thank you, Chair.
Thank you very much. That concludes the presentation for Bantu for Global Equity. And I see the member is appreciating your input, and that we would welcome whatever literature you can share with us through the committee secretary. Thank you very much. Can I now hand over to COSATU SACTU, Mr. Matthew Parks?
Sorry, Chair. Oh, okay. Sorry, Chair. No, good morning, Chair. Thanks to members for giving us space as well. So this is a joint presentation by COSATU and our affiliate, SACTU, Southern African Clothing and Textile Workers Union, which organizes, obviously, in the clothing and textile, agriculture, or many other industries. And Etienne Flock will lead us in the presentation. He had led our negotiations on the bill at NEDLAC, and so he's got a lot of expertise on it. Chair, I think we just want to make kind of a few points before Etienne gets into the presentation. One is that this bill is very important to COSATU and we think to workers in the economy at large, largely for three reasons. I think number one is that we have felt the pain and the consequences of grey listing last year, largely because of outdated legislation, including the Companies Act. And that has a huge negative impact upon the ability to attract investment, to create jobs, etc. And we bear that in mind because of an unemployment rate of 42%, a youth unemployment rate of 60%. We're struggling to attract domestic and foreign investment. Chair, we also think that the bill is important because currently our laws are not really in line with international best practice. Our laws are not kept pace with international legislative trends. So here's a positive opportunity to address that issue, to update our laws, etc., especially the Companies Act. And I think, again, the grey listing last year and the necessary amendment we had to do around the General Laws Amendment Act spoke to that. So we also have the infamy as South Africa being the most unequal nation in the world because of our legacies of apartheid and so on. There's a huge pay discrepancies, which are unsustainable in the private sector, between the highest and the lowest income earners. This really creates a huge gap around our efforts to address inequality. So, for example, in the retail, the banking, the mining industries, you find CEOs getting paid a million rand a day often. Yet the very same bank tellers, clothing workers, retail workers would be lucky to make 100,000 rand in a year, probably far less than that. And often we forget that it's workers' pension funds which are invested in these companies across the market. So really it's workers' money which drives these companies. There's often very little accountability for the seemingly paid salaries to these executives, and they're not often linked to company performance. But of course, Chair, when companies do that, it creates labor market instability. It raises demands for workers that, well, we should also get paid a better wage, since clearly the CEO can afford to do so. And at times also, Chair, we think the bill is useful because it begins to compel companies to share their financial status, the financial records with workers. That helps to rethink to boost labor market stability. So let me stop there, Chair, and hand over to Etienne. But thanks, Chair.
Hey, good morning, and thank you very much for having us today. It may be worth just starting out by apologizing for Matthew not putting on his video. I understand he didn't brush his hair this morning, so I hope you'll excuse us. Just on a lighter note, Chair.
Okay, maybe he has as much hair as you.
Thank you.
Okay.
Thank you, Chair. Chair, perhaps just before we start with the substance of the bill, a little bit on the NEDLAC negotiations, and we share this with you because it's an important context to this bill. We had very tough negotiations at NEDLAC. It was interrupted by COVID, but it started in 1919 and then concluded in 2021. It was very good negotiations, and there were significant concessions made by all sides. And out of all the clauses currently covered by the company's amendment bill, there were only two areas of disagreement. And a lot of the clauses that you now see in the bill, Chair, were amended following business inputs and concerns. So business had indicated they can't live with this. This would be practically too difficult, and hence the bill was amended. And we must stress that while what is currently before you is not always Labour's first choice, we recognize that the outcome of it is the product of social dialogue and of compromise. And so you will find us supporting the bill. We are concerned when our partners, including its affiliates, BUSA, the CGCSA, Agribus, etc., come here and fight about clauses which ultimately BUSA agreed with during the negotiation. So it's a real concern for us that our partners are acting like this. And Chair, of course, if the Portfolio Committee would like the NEDLAC report, I'm sure the department would be able to supply it as NEDLAC would. So, Chair, in these submissions and presentations to yourself, you would have seen an enormous amount of scare tactics by some in business. I mean, I saw a report in the Business Day a couple of days ago, which described this as the worst in the world. So absolute mayhem, chaos that will come from this. And you will have probably seen things like it adds administrative burdens. A lot of people in business saying it diminishes South Africa's attractiveness as an investment destination. It will scare away potential CEOs or directors. It will reveal private information. It's not in compliance with the POPI Act, and it will cause chaos between directors and shareholders. Once again, something that the CGCSA just mentioned to us as well. In our submission, and Chair, we won't run through all of this because of the limited time we have, but in our submission, we deal with all of these claims. The simple thing is that this legal framework, just to deal with some of the claims from some people in business, the legal framework in the company's amendment bill is already employed in other countries, and we'll talk a little bit to it. But in our submission, you'll see that in the negotiations, BUSA itself, Business Unity South Africa, came forward and indicated to us what is in the bill fits in with what happens in many other countries. And we cite those, and it's also cited in the NEDLAC report. The current lax corporate regime creates a space for businesses to try and capture the state and to be corrupt. So it needs to be tightened. Companies' information is not automatically private, and the privacy legislation creates space for companies to share this info. And then an important point which we'll return to, but that customers, suppliers, and communities need to know who are the companies they interact with. If companies act in the dark, then a supplier or a customer would not know what's happening in that country, in that company, would not understand the bona fides of that company. It would be very difficult for them to interact, to supply, or to buy from that company. Chair, international investors are weary of South Africa because of the lack of transparency in our companies' law and because of our widening inequality. It means that they think it's risky to invest in South Africa. So it's not that this law will chase away investors. In actual fact, it may provide them with some comfort when they invest. And then importantly, our inequality needs important interventions. Comrade Matthews spoke about it. The previous presenter, Elisa Nkomo, spoke about that. We can't just sit idly by and just leave our inequality. And then finally, our CEO salaries are out of touch with reality, but importantly, also out of touch with what shareholders are expecting. I want to take a step back because it can't be that we judge this act and amendments based on what corporate governance looked like in the 1970s and 1980s. At that stage, it was very much about shareholder interest, but we've moved on and it's about stakeholder interest now. So I wanted to provide a quick quote from Professor Michael Katz, who's the chair of ENS Africa, who's the largest law firm in South Africa, and he's a specialist in corporate and commercial law. He said, there is wide recognition by experts in corporate governance, including academics and senior business leaders, that the duties of directors are not confined to advancing the interests of shareholders. There are other stakeholders whose interests are also relevant and require recognition. These include employees, customers, suppliers, the local community, and the environment, amongst others. We provide this to you because we've moved on from the 1970s and 1980s corporate governance, where it was only about shareholders, to more broadly about stakeholders now. If we can move to Section 30 and Section 30A, the remuneration report provisions. The company's amendment bill will allow shareholders to rein in excessive executive pay and provide more information on pay gap. Now, we know that the King Committee was here. We know that many people are citing the King Report on Corporate Governance. So we wanted to provide a quote to you because we think this King Report actually assists the bill and backs it up. The King 4 says, the remuneration of executive management should be fair and responsible in the context of overall employee remuneration. It should be disclosed how this has been addressed. This acknowledges the need to address the gap between the remuneration of executives and those at the lower end of the pay scale. And then a further quote from the Business Day newspaper, which is obviously not a left-wing newspaper, which is the newspaper of companies and the newspaper of business in South Africa. Their deputy editor in an op-ed last month wrote the following. He said, the company's amendment bill would require public and state-owned firms to disclose their pay ratios and seek shareholder approval for their remuneration policies. The move is not only justified, but also necessary. And then he cites the OECD. He says the OECD Principles of Corporate Governance, the global standard for corporate governance, recommends that executive pay should be transparent, aligned with long-term value creation, and subject to shareholder oversight. Okay, then to get into some of the specifics on Section 30A, we think that this section will provide more information about wage inequality and excessive executive pay. And as we said, it's aligned with King 4 and the global developments. And then you'll even find that Cliff Decker, once again a corporate law firm, wrote that on balance, the proposed inclusion of the majority of Section 30A is a positive development for corporate governance that would align South Africa company law more closely with international best practices. And then, if we start looking around, so while some would come and describe this as the worst in the world, in actual fact, it's not. It's not nearly the case. It's current practice in other countries, such as the US, the UK, and Netherlands. But there are also South African companies that already practice this, that publish the pay gap, that publish the lowest paid, including Absa, Investec, the JSE, Nedbank, Old Mutual, Shoprite, and Standard Bank. So when somebody describes it as the worst in the world, it's really just scaremongering. And what they really want to do, Chair, is continue to operate in the dark. Chair, we support sections 30A, 4, 6, and 9 that will make shareholders vote binding. The CGSCA SA discussed a little bit of that. We think the existing remuneration system is broken. Executive salaries are unjustifiably high and out of sync with the country. Shareholders cannot hold directors responsible anymore. And this executive remuneration drives inequality and causes widespread discontent among shareholders, workers, and the public. And the current advisory vote regime serves no purpose. In addition, this new amendment in Section 30A is in line with the Australian system. I'm not going to go through this, but this is a quote from the Business Day newspaper deputy editor again, talking about why it's so important to have this section and that it's fully justified. Just quickly, the schematic, Chair. So there's a lot of complaints about Section 30A, but we think it's totally justified. We provide 4 examples here, what Labour's position was in the initial negotiations, what the JSE current rules say, what the Australian example looks like, and then what's suggested in the company's amendment bill. Firstly, on the vote, Labour wanted a special resolution. In other words, we wanted 75% of shareholders to approve the remuneration report vote. The current JSE support. In Australia, they require 75% support, but the company's amendment bill puts a lower threshold, only 50%. So in other words, the company's amendment bill cannot be the worst in the world when the Australian one is worse, when what is currently in the JSE is even stronger. So the company's amendment bill is in actual fact slightly more relaxed than we have in Australia and even than the current JSE rules. We've included the number of votes. In Australia, they vote twice, but in the current JSE rules, it's only once. The company's amendment bill says once. In terms of whether it's a binding vote or not, in Australia, it's a binding vote. The current JSE rules says it's not a binding vote, and the company's amendment bill says it's a binding vote. We absolutely support this. The fact that it's not a binding vote in terms of the current JSE rules means there's absolutely no consequence. Shareholders vote against the remuneration report. There's only consultation that happens, but no consequence. And you'll also see, Chair, we provided the consequence or the outcomes. In Australia, much stronger than in South Africa, because the entire board would need to stand for re-election once there's votes against the remuneration report. In the South African legislation, the proposed legislation, it says only the remuneration committee would not be eligible for for standing again for the remuneration committee. So also weaker than the Australian standard. Chair, and then quickly to move to a couple of other areas. The one proposed amendment we would suggest is in Section 30A. At the moment, it only applies to listed companies and to state-owned companies. BLSA previously and senior business leaders came out to say it should apply to privately owned companies as well. We support this call because many unlisted companies are significantly bigger than listed companies and have similar pay gaps, and we've suggested some wording in our submission on how that can be done quite easily. Then, to get to the access and transparency provisions, we support these. We think it will improve, deepen, and broaden the access to company info, and it's in line, once again, with global practices, as BUSA showed in the NEDLAC negotiations. You'll find references to that in the NEDLAC report, and we've also quoted that in our submission. We think the company's amendment bill provisions will help to provide oversight. It will allow parties to shield themselves from risk. It's crucial in saving jobs, determining fairness in pay, and uncovering fraud, and can assist the media to reveal conflicts of interest and corrupt practices. There will be all kinds of criticisms about why company information cannot be shared. But we think these enhanced transparency and access provisions are based on the recognition that corporate activity has wide social impact. And then we cite the Constitutional Court, who in 1996 spoke about the fact that establishment of a company as a vehicle for conducting business on the basis of limited liability is not a private matter. And we quote there what the court says, that in actual fact, there should be proper disclosure and accountability. And then others would have cited, Chair, to you that the POPI Act does not allow for the sharing of info. That's incorrect. The Act allows for the sharing of info. It just says how it needs to be done. And in addition, in Section 37 and 38 of the POPI Act, it lists grounds on which the processing of information is not in breach of the Act itself. Then in terms of Sections 26 and 33, that provides for access to company info, we believe workers, unions, and others should have access to more info than currently in the bill. We think, for instance, we should also have access to meeting minutes, reports to annual meetings. But in the NEDLAC negotiations, there was resistance from business on these sets of information. And hence, when you look at the bill, it doesn't include meeting minutes and reports to annual meetings. This was the outcome of the negotiation, Chair, and we respect that. It's captured in the NEDLAC report, and we've conceded that. So we share we support the current Section 26 and Section 33 of the bill, although we would have preferred more information be public. The one additional amendment we would propose would be to Section 25(2), which talks about how information is shared. Chair, it says at the moment that the information, that the Commission must publish the information at the start. We would suggest that it be tighter than is currently suggested, and we say that the committee should amend the Act to say the bill, to say that the Commission must publish the info on the website of the Commission. And then the final slide, Chair, is to say that it's a technical issue that we are concerned on beneficial ownership. This was largely covered when the General Laws Amendment Act came into power last year. That dealt with beneficial ownership. But we think that because it was such a rushed process, there's currently a conflict between Section 1 and Section 56 and definitions between beneficial interest, beneficial ownership. We are concerned it's not in line with FATCA, like prolonged listing. And so there's some proposals on basic beneficial interest, beneficial ownership, and also on streamlining provisions, obligating companies to ascertain who the beneficial owners are, and obligating reporting. Some others have dealt with this in detail, including Corruption Watch and Garnet, but we urge the committee to look at this and advise to look at this to make sure that we use opportunity to deal with any conflicting definitions.
Mr. Flock, just a minute. I just want to check, Committee Secretary. The line is deteriorated. Is it just on my side, or?
I think it's on all our sides, Chair.
Yeah, I think if you can switch off your video and let's see if we can improve the bandwidth, Mr. Flock. Thank you. You can proceed.
Thank you, Chair. Chair, I've actually concluded now. If you'd like me to repeat anything, I'd be happy to do so. But this is the end of our presentation. Thank you very much, Chair.
Thank you very much, Mr. Flock, and to Mr. Parks. I see the hand of Honourable McPherson. Any other hands?
Thank you very much. Unless Mr. Parks has had a miracle of hair growth, I think that he might have also been struggling. Or I think the excuse by Mr. Flock might not have been true, but that's also just a light-hearted moment. Thank you to Mr. Park and Mr. Flock. I just want to ask two questions, if I can. Essentially, the first part of the presentation is focused on CEO pay, director fees, so on, and I don't think that is an unfounded debate to have, but I would just ask do you think it's fair what you've anchored it on, that CEO's pay is out of sync with the country? That was how it was framed. But that in itself wouldn't be a fair comment in my view, because CEOs can't be held responsible for the failures of the economy by the current government. So I would just like, is that the implied position of COSATU, is that CEOs now bear responsibility for the state of the economy? Because if it would be, I don't personally agree with that sentiment. It seems that one of the big things that everyone is stuck on is around the binding vote of the remuneration for the remuneration committee. And I mean, we've heard strongly, including from BUSA, why they disagree with your position, that it should be a binding vote. Can I just understand why you're so fundamentally opposed to the position of BUSA on the remuneration committee? It's not entirely clear to me why you think it should be right that a member of the remuneration committee would have to step down after a single vote, and how that in itself actually drives greater transparency or accountability in remuneration. That's it from me, Chair. Thank you.
Thank you, Honorable Malamacha.
Thank you, Chair. Let me take this opportunity and welcome the presentation, and further say, Chair, the tone of COSATU is pro-poor, is pro-workers. The tone of COSATU is what the country's constitution stands for, that transparency must always prevail. It is not transparency for the sake of any other thing except to say information must reach everybody and everybody must have access to information. That alone provides good governance where there's no hidden items of some sort. Chair, if we are to welcome their presentation, citing some example, though they never touched, it's very painful and heartbreaking to find a CEO, if we have to be specific on that particular example, earning millions, whereas the very same worker where they're working same place and the worker is contributing equally to the CEO, because the CEO is oversighting, the worker is producing, but the salary of the worker cannot even take a petrol tank of the CEO. Now, we are saying, COSATU, you are very spot on to the bill, because the bill tried to let things be done correctly. The issue of the stakeholders being undermined, the issue of the stakeholders being undermined is the problem that caused the likes of BUSA to come in. But should BUSA allowed to be governed and allowed to remain your affiliate, will understand that you are giving proper direction of every amendment bill with the interest of the people. The other contribution I want to make on your proposal, COSATU, where you are taking of information, the access to information, I think it's noted, it's just it needs to further, but you wrote the handling of it. One will want to see a situation where it further says confidentiality needs to be respected on that, and the misreading be much watched out, because normally it's not the problem of information given to the people. It's how people are dealing with the information given to them. You'll find that they are misinterpreting, reading it out of context, and making public even those that are not. But I think all in all, I wanted to really welcome and appreciate the support of COSATU and the manner they outlined and gave the objective of this amendment bill. That is what we are here for. Thank you, Chair.
Thank you very much. Over to COSATU for responses and clarities as requested.
Thank you, Chair, and thank you very much to Honourable Macpherson and Honourable Malamacha for the questions and comments. Chair, firstly, with regards to Honourable Macpherson's question. Honourable Macpherson, it's important to note that when we say it's out of touch with the country, we're not saying it's out of touch with the current economic conditions. I mean, that wasn't the statement. In other words, you drawing a link between, us saying that the current high CEO salaries are causing the economic problems, and that's not at all what we said. We said it's out of sync with the country. In other words, out of sync with a country where there is enormous inequality. It's out of sync with a country where there is enormous poverty. It's out of sync with a country where many people struggle to make ends meet. It's out of sync with a country where wages in many sectors are extremely low. It's out of sync with a country where the national minimum wage is very low. And what does that mean? It means that because it's so high, it helps to drive inequality. Because it's so high, it undermines nation building, because there's no way that we can have a joint project where a lot of people are not just earning high salaries, Honourable Macpherson, but earning disproportionately high, unjustifiable salaries, and for that reason we say it's out of sync with the country. It undermines a lot of what we're trying to do. It undermines the efforts by all to build a country. It undermines our ability to get workers to work with managers when they receive very low wages at the end of the week, but the manager has a Porsche that's parked in the parking garage. So it creates all kinds of problems for us. And we think that this would be, publishing this information will help to start to shine a light on this pay gap. And in that way, as soon as you start to shine a light on the behavior, it starts to, we think, rein in that behavior to some extent. So, in terms of your second question, Honourable Macpherson, on the binding vote for the Remuneration Committee, the very funny thing is, Honourable Macpherson and Chairperson, to yourself as well, if you go and look at the NEDLAC report and the negotiations we had 2019 and 2021, in the NEDLAC report, business agrees to this vote, Honourable Macpherson, on the Remuneration Committee being binding. Right? So Chair, I don't want you to believe me on this. I want you to ask NEDLAC or to ask the DTIC, please, to provide you with that report. And in that, Honourable Macpherson, you'll see that business actually agreed to this. And this is after negotiation, after compromises on both sides. But now it seems they've gone back on this. Why? But regardless of that, why do we think it's useful? Firstly, at the moment, there is not any consequences. So, Honourable Macpherson, if you read the newspapers, you'll see there are constantly votes shooting down the remuneration reports from companies, where they talk about enormous amount of shareholders voting against remuneration reports because they're not happy with what the CEO is earning, and they feel it's not in line with the results of the company, and it's not in line with similar companies, etc. But at the moment, there's absolutely no consequences, Honourable Macpherson. It means that when that happens, and you'll see constant references to that in the newspaper articles. So when the shareholders vote against it, there's a bit of interaction, and that's the end of it. So we think this is important because for the first time, there'll be an actual outcome. It's binding. In other words, something needs to be done about it. It can't just be a loose discussion. Why is it important that the remuneration directors stand or won't be able to be on the remuneration committee anymore? We think it would make them take their job more serious. We think it will create a general seriousness in this whole idea on the voting on the remuneration report, both by the shareholders, but also by the directors. And we think in that way will help to rein in unjustifiable and sky-high salary packages. And in that way, as I said previously, help to deal with inequality, but also help to deal with our kind of broader nation-building project. Chair, Comrade Malamacha is spot on. You know, the interesting thing about this is, you know, I said earlier that what is in front of us in the bill is not our first choice. Ideally, what we would have wanted, Comrade Chris, is we would have wanted an actual cap on the gap between CEO salary and worker salary. You know, we would have wanted this bill to set out, you know, that the CEO salary cannot be higher than a certain ratio. But, you know, we understand at this stage it's not quite possible. And in the negotiations, we settled on something different. But at some stage, this is still something that we will pursue. We also agree with Comrade Chris that the confidentiality matters are dealt with, that there's enough space to share information because of the current confidentiality regime, including the POPIA Act and others. So, Chair, I think that covers it. I understand Comrade Matthew may want to add something. Thank you very much, Chair.
Thank you very much, Mr. Parks.
Thanks, Chair. Let me also defend my receding hairline, and I think Honourable McPherson may join us soon, though I think he's better off than Mr. Flock and myself, who are aging disgracefully. But Chair, I think just to thank members for the questions, and I think maybe to make 3 quick points. To Honourable McPherson's point about the CE pay, is it out of sync with South Africa? We think no, definitely it is. The fact that the CEOs of the big 5 banks on average earn about 150,000 rand every single day of the year, whether or not they work or not, they earn it. A bank teller would be lucky to get that in 2 years' time. And yet at the very same time, we had seen 4 of the big 5 banks in recent years retrenching about 2,000 workers each. So there is an issue there of morality and also how we ensure a better, more humane, more inclusive society and economy. Compared to national best practice and worst practice, we think we are falling significantly far behind. And it creates labour market instability. We would remember with the Sibanye strike last year when mine work was asking for an additional 150 rand a month. Management was refusing, yet the CEO of that company was earning about 330 million rand in a year. So, of course, it's going to fuel labour market stability when workers will ask, well, we can't even get money to buy Streetwise 3 at KFC. But the CEO will earn more than we could earn in a few centuries as workers. We shouldn't be proud that we are the most unequal nation in the world, despite all of government's best efforts since 1994 on the social wage, shifting 60% of the budget towards the poor, etc. But we're not going to overcome that if we don't all pull together. And sure, we can ignore the inequality levels, and the consequence of where that will lead us to is to Zimbabwe, where they didn't deal with issues of fundamental transformation for many years, and one day it blew up. And it's not a far-fetched reality. And leave aside the criminality and all the other orchestration of the July 2021 violence in South Africa and Gauteng and KZN, but really it fed into a sea of poverty, of despair, of hopelessness. We can't afford that. The damage, from that violence was about 50 billion to 100 billion rand to the economy. It's far better to pay people a bit of a living wage than to play Russian roulette with all of our lives. I think she'll also make the point. So the biggest investment fund, not only in South Africa, but the continent, is the Public Investment Corporation. And that is workers' monies, the GPF, the UF, etc. They are invested throughout the economy. So every single company listed in the JSE, the largest shareholder on average is the PIC. So workers have a right to say, we think that it's better that companies begin to pay workers a living wage, begin to reduce the exorbitant packages paid on top. And we're not saying you must pay the CEO a minimum wage, but can we have a bit more of a decent, less obscene approach to it? If we want to boost company productivity, we need to pay workers a living wage so they can buy the food, pay for the transport, pay for the healthcare costs of the families. They can be motivated. And it's difficult to think, how would someone who is paid so little, they don't even qualify to pay income tax, would be motivated when they see the CEO of a retail sector company getting paid 150 million rand in a year. So, the government would make noise about the wage gap in the public sector, correctly so, but it's about a third of the gap of what you see in the private sector. So we think we need to have this thing. And again, the bill doesn't, all it simply says is that, well, disclose what you pay. You shouldn't be afraid to disclose it if you're not embarrassed by it. I think to Honorable Malamacha's point, that the transparency issue is very important. We've seen that corruption is not solely a prerogative of the public sector, it's in the private sector too. We've seen the issues of Steinhoff, of Tongaat, etc. We've now felt the consequences because the international community is not taking us seriously anymore. Hence, they've grey-listed us. And one of the issues we have to deal with is about business transparency. So the GLA Act that Parliament passed correctly last year, it makes provisions, but we need to make sure the Companies Act or Companies Bill is in sync with it. And again, Chair, it's going to boost labour market stability because if workers can know what is the financial situation of the company, the expectations, the demands will be better informed and then better in sync with it. You don't want the workers to think the company is making a fortune and hence they'll demand significant wage increases if the company is actually bleeding and vice versa. So it's actually going to benefit companies. It's going to help to expedite negotiations to all parties benefit, etc. And I think our point, Chair, as Etienne was saying, is that let's make sure the disclosure of business ownership, the finances, etc., is readily accessible, it's available to the public, to the media, to shareholders, etc. But I think lastly, Chair, we think the bill is a fair compromise. As Etienne was saying, many compromises were made by government, by Labour, by business. It's a decent product, and I think our kind of plea to the honourable members is to defend the bill, to see where can we strengthen and enhance it, enrich it. We should not water it down. And I think lastly, Chair, we appreciate you have huge pressures on yourselves as members in the committee, just for us to ensure that we do expedite the bill, and that as we conclude this sixth Parliament, that this bill is passed by both houses and is on the President's desk for his assent, etc. It's been a long journey, but we're looking forward to being passed, and I think it'll help take us forward collectively as government, business and labour at the end of the day. But thanks, Chairperson.
Thank you very much to the presenters of COSATU and SACTU. That, members, was our last presentation. Thank you to everybody all the stakeholders who have presented to us today. As we have said in our previous days of public hearings, that we will take all submissions into account when we deliberate. Thank you very much for your participation. Can I now just ask the committee secretary to take us through on the way forward regarding the bills and any other work that the committee will be doing during next week? Committee Secretary.
Thank you, Chairperson. The committee is scheduled to get a briefing from the DTIC on the issues that may have arisen, as well as from the parliamentary legal services from the legal perspective, technical perspective on issues that were raised during the submissions. Chair, we then scheduled for deliberations on Wednesday. Chair, just to alert members that the parliamentary program has subsequently changed. We were originally scheduled to continue with deliberations on Friday, and we have scheduled to consider our BRRR formal consideration for that day. The first draft consideration will take place on Wednesday, Chair. We're proposing that we, because of the mini plenaries happening, do deliberations on that day, but we are required to adopt our BRRR report, Chair. So if we can maybe meet from 8:30 to 9:30, that will still allow members to join mini plenaries that start at 10 o'clock. With your permission and the committee's permission, Chair. Chair, we have concluded the first draft of the BRRR report, and with your permission, we can distribute it to members, requesting members to make submissions, concluding remarks, and any recommendations they wish to make, so that we can look at it on Wednesday and allow members to take it to their respective caucuses on Thursday, and then formally adopt the BRRR report on Friday, Chair. I think that's all from my side, Chair. Thank you.
Thank you very much, Committee Secretary. I just want to request that we do a follow-up with the developmental economist the development economist that was on the platform, who promised to send us some literature. And then also think if it's not part of the DTIC briefing on these bills, that we request the department to brief us on or send us the NEDLAC document, so that we prepare ourselves for deliberations.
Chair, we can source that document, Chair, and hopefully we'll distribute it to you soon, Chair.
Okay, thank you very much. That concludes our deliberations for the day, and the meeting stands adjourned. Thank you very much.
Thank you, Chair.
Thank you.
Thank you, Chair.
Long live the chair. Long live the chair.
Thank you, Chair.
Recording stopped.